ಯಾರು? ಕೊಡಿ ಸರ್.
ಹೇಳಿ ಸರ್, ಏನ್ ಬೇಕು? ಇನ್ಚೇಂಬರ್ ಸೆಪರೇಟ್ ಆಗಿ ಎತ್ತಿಕ್ಬಿಡು, ಲಾಸ್ಟ್ ಆ ಕಡೆಗೆ. ಒಂದೇ ಚೇಂಬರ್ಗೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಇದು ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ಮೇಡಮ್ ಕರೆಯೋದು?
ಇಷ್ಟು ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರತಿದಿನ ಯು ಆರ್ ವಾಚಿಂಗ್ ಹೌ ಇಟ್ ವಿಲ್ ಬಿ ಗೋಯಿಂಗ್ chronological.
After finishing the first up to third list, then fourth list will be called.
ಅದೆಲ್ಲ ಯಾವಾಗ ನಾವು ಲಿಸ್ಟ್ 1 ಕಮೆಂಟ್ಸ್ ಆದ್ರೆ ಕ್ರೋನಾಲಜಿಕಲ್ ಆಗಿ ರನ್ ಆಗುತ್ತೆ. ಅದು ಲಿಸ್ಟ್ 1, ಲಿಸ್ಟ್ 2, ಲಿಸ್ಟ್ 3, ಲಿಸ್ಟ್ 4 ಲೈಕ್ ದಟ್.
Okay, got it. After finishing up third list, then you will be go to fourth list.
ಸರ್ ಹೌದು, ಪೇಜ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮುಗಿದ್ಮೇಲೆ ರೆಗ್ಯುಲರ್ ಆಗಿ ರೋಸ್ಟರ್ ಕಮೆಂಟ್ಸ್ ಆಗದೆ ಒಂದೇ ಲಿಸ್ಟ್ ಇಂದ.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಮೀಡಿಯೇಷನ್ ಅಂದ್ರೆ ರಿಪೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ
ಮೀಡಿಯೇಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ರೆ ಇವಾಗ ಈಗ 3 ದಿನಕ್ಕೆ ಏನು
ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ರಿಪೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ
ಹೇಳಿ ಸರ್. ಮೆಮೋಸ್ ಎಲ್ಲ ಸರ್ ನೋಡಿ, ಎಲ್ಲ ಡೇಟು ಎವ್ರಿ ಡೇ 50 ಇದು ಎಕ್ಸೀಡ್ ಆಗ್ತಿದೆ
ಮೇಡಮ್. ಫ್ರೆಶ್
ಅಲ್ಲ, ನಿಮ್ಗೆ ತೀರಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ. ಇಲ್ಲ ನಿಮ್ಗೆ ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂದ್ರೆ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಡಿ. ಯಾಕೆ ಅಂದ್ರೆ ನಮ್ಗೆ ಈಗ ನಾವು ಬರೋದ್ರು ಲಿಸ್ಟ್ ಆಗಲ್ಲ ಅದು. ಯಾಕೆ ಅಂದ್ರೆ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಎವ್ರಿ ಡೇ ದೇರ್ ಆರ್ 50 to 55 ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಆಗ್ತಿದೆ ನಾಳೆಯಿಂದ 50ರಿಂದ 55 60 ರೀಚ್ ಆಗ್ಬಿಟ್ಟಿದೆ
ಮೇಡಮ್ ಫ್ರೆಶ್
ಆಗ್ಬಿಟ್ಟಿದೆ. ಅದಕ್ಕೆ ನೀವು ಮೆಮೋಸ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ತೀರಾ ಅಂದ್ರೆ ನೀವು ನೋಡಿ
ಹಾಕಿರ್ತೀವಿ ನೋಡೋಣ.
ಏನ್ ಸರ್
ಫ್ರೆಶ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ನೀವು ಅಲ್ಲೇ ಡೈರೆಕ್ಷನ್ ಇದೆ ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕಿಲ್ಲ.
ಬರುತ್ತಾ ಫ್ರೆಶ್ ಇದ್ರೆ
ಅಬ್ಜೆಕ್ಷನ್ ಒಂದು ಇಲ್ದಲ್ಲ ಇದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಅವ್ರಿಗೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಇಟ್ಕೊಳಕ್ಕೆ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ P&H ಮುಂದೆ ಹೋಗ್ತಾ ಇದೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿ ಡೈರೆಕ್ಷನ್ ಆಫ್ ಎಲ್ಲ ಯಾವುದು ಇಟ್ಕೊಳ್ಳಲ್ಲ ಸರ್ ಅವರು. ಖಂಡಿತ ರೀಚ್ ಆಗುತ್ತೆ. ನಿನ್ನೆ ಎಲ್ಲ ರೀಚ್ ಆಗಿದೆ.
ನಮ್ದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರನೇ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಕೊಡಿ ಸರ್.
ಎಲ್ಲಿ
WPFC ನಾ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹೋಗಿ ನೀವು ಕೊಟ್ಬಿಟ್ಟು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡ್ಕೋಬೇಕು ನೀವು.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಒಂದು ಬರೀ ಸಿಗ್ನೇಚರ್ ಹೆಸರು ಬರ್ದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನೋ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಮಾಡಕ್ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹೋಗಿದ್ರೆ ಬರಲೇ ಇಲ್ಲ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನಾದ್ರೂ ಆಗಿದೆ ಎಲ್ಲ ಹೇಳ್ಬೇಕು. ಇದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಬರಲ್ಲ ಸರ್.
ಸರಿ
ನಾವಿಲ್ಲಿ ಬರೀತೀವಿ ಇಲ್ಲಿ ಆಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಡ್ ಅಂತ. ಅದೇ ಇದೆ ಮ್ಯಾಟರ್ ಏನಾಗಿದೆ ಯು ಹ್ಯಾವ್ ಟು ಟೆಲ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್. ಕರೆಕ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಕರೆಕ್ಟ್ ವೆದರ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಡೀಷನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದಾರಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ರೆ ಬರಲ್ಲ ಸರ್. unless the office objections are complied by the petitioner counsel the matter is our objections complied. First you see the status of the file. What happens? ಬರೀ ಯಾವ್ದು RPFC ಕೊಟ್ಟಿದ್ದು ಬರೀ ಅಡ್ಮಿಷನ್ ಗೆ ಇಲ್ಲ ಸರ್. ಎಂಟ್ರಿ ಮಾಡುವ ಏನಿಲ್ಲ ಏನಿಲ್ಲ ಬರೀ ಅಡ್ಮಿಷನ್ ಗೆ ಲೆಟರ್ ಕಂಪ್ಲೀಷನ್ ಅಂತಾರೆ ಮೇಡಮ್. ಎಂಟ್ರಿ ಮಾಡುವ ಕೇಳಿದ್ರೆ ಮಾತ್ರ. ಮತ್ತೆ ಲಿಸ್ಟ್ ಟೂನಲ್ಲಿ ಯಾವ್ದು ಬಂದಿಲ್ವಾ? ಟೂನಲ್ಲೆಲ್ಲ ಇದೆಯಾ? ಟೂನಲ್ಲೇ ಇಲ್ವಂತೆ. ಟೂ ಯಾವ್ದಿಲ್ಲ? ಹೌದಾ? ನೀವು ಚೇಂಬರ್ ಇಂದ ಯಾವ ರೆಕಾರ್ಡ್ ರಿಪೀಟ್ ಮಾಡ್ತಿದ್ರೆ ಆ ಕಡೆ ಇದೆ. ಇಲ್ವಲ್ವಾ ಮೇಡಮ್? ಎಲ್ಲ ಕಲಿಸಿ ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಎಲ್ಲ ಕಲಿಸಿ. ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಏನಿದೆ ಅದೇಪ್ಪ ಹಿಂದೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಏನಿದೆಯೋ ಸೇಮ್ ಆರ್ಡರ್ ಟು ರೀಇಶ್ಯೂ ಡ್ರಾಫ್ಟ್ ಅದು ಈ ಶೆಡ್ಯೂಲ್ ಇಸ್ ದ ಡ್ರಾಫ್ಟ್ ಡೇಟ್ ಮಾತ್ರ ಚೇಂಜ್ ಆಗುತ್ತೆ ದ ಸೇಮ್ ಪೇಪರ್ ಸೇಮ್ ಎಡಿಷನ್ ಎವ್ರಿಥಿಂಗ್ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಟು ದಟ್
ಒಂದು serial number 21 month ಬರಬೇಕು.
yesterday initiated vendors are there. What is the date? Yeah, initiated vendor. ಒಂದು ನಿಮಿಷ ಹಂಗೆ initiated before ಕೊಡ್ತಾ. ಇನ್ನೊಂದು 5:30 ಇದ್ದಿದ್ದು ನೋ 5:30 ಇದ್ದಿದ್ದು ಅದು ಯಾವಾಗ ಡೇಟು ಕೊಡ್ತಾರಾ? ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡಿಪ್ಪ. ಅದೇ ಡೇಟ್ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ಬೇಕು ನಮಗೆ. ಯಾಕೆಂದ್ರೆ ನಾವು ಕಂಪ್ಯೂಟರ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ಬೇಕಿಲ್ಲ ನಮಗೆ ಉಳ್ಕೊಂಡ್ಬಿಡುತ್ತೆ. ಮಾಡಿ ಏನಾಗಿದೆ ಕೊಡ.
That's one mention, my lord. Well, it's in this matter, my lords had disposed of the matter. It's a divorce proceedings, fixing time frame, my lords. My lords had also ordered for my lords filing of assets and liabilities by both the parties. Now, my lords, a peculiar situation has arisen where the wife does not want to seek any maintenance. So she wants to, my lords, she does not want to file assets and liabilities. She is seeking only divorce simpliciter, my lords.
Why, after doing all this exercise,
No.
coming to the High Court?
Well, let's know. It was challenged by the husband. When interim maintenance was ordered, she has not sought for.
No. That means there are suppression of facts in the first instance, which the wife do not want to. Let her file. Let the court will not grant. Let the court will not grant. Let her file a statement of this.
Well,
Why did you sought for maintenance?
Well, it's because the child was still small and now she's doing well in her profession. She's a dentist by profession.
Say, don't file.
And it's a decade-year-old litigation,
No,
Malats.
court will not grant you maintenance. Will not let you go scot-free like that after making all false statements before the
My humble submission is, Malats,
Here, I'll not.
only
I'll
in
not grant.
maintenance proceedings it's mandatory to file assets, Malats, because the
No, that's
court
what
has
we-
to
no,
make.
Now, by filing this petition, by permitting you to move this application, you will be compelling me to write a detailed order on that. It's for you. To file the same memo before the court saying that I don't want whatever the court
My
considers
lords, the
is fine.
court did not entertain because there is a specific order from this honorable court.
I will, if you want. Huh? On that. No, if you want, I'll give the, memo will be given and the matter will come. But I'm telling you, I will, if it comes before me, I will write a detailed order on that.
My lords, I may have to
And
take
I'll
a
be-
chance, my lords.
Then you will be taking it and I will not permit you to withdraw also. Once the court starts passing the order, I'll not permit you and I will pass a detailed order which will go to the root of the issue and it will be at your this thing. You please think about it and do.
In fact, I was seeking an observation.
No.
In the,
I will not.
In the light, my lords, that.
That's why I'm indicating. You move it, we'll grant it, we'll take it tomorrow, but I will pass a detailed order. What is the intent behind this? And we will not leave any of the party to take advantage of. And why did you file an IA? What all happened? Why you don't want to file a statement of SSL liabilities? Because the statement of SSL liabilities earlier filed are all.
No, it was not filed earlier, my lords. It's a decade-year-old litigation. No assets have been filed until now. And I'm not asking the husband also to file. Both parties may waive. I'm not intending to know what assets he owns. And I have a child. I will take care of my child.
There should be a noble cause behind it. That's why you don't want to do it.
Well, it's whatever it is her choice not to be maintained by the husband, my
Don't
lords.
tell me whatever it is. Whatever it is, court, if you ask the court, you have to tell what it is. Can't be whatever it is. Give it tomorrow. Yes.
Lords, fresh matter, my lords, kindly tomorrow, my lords. The trial court has ordered for the grant of interim custody to a minor child to the mother, my lord, on 30th of September and 2nd October, my lord. The kid is not interested to go with the mother, my lord, because of the bitter experience earlier occasion. She has ill-treated that kid, my lord. She has not provided the proper food and all. Now the kid is
Not provided proper food.
food and
That's
all.
the reason this court interfered. Take it. Everything, all these kind of matters which are seeking a memo now, they'll be doing it at their cost. Yes.
Your Ladyship, I'm appearing for the mother in this matter. Mother is a resident of Bangalore, father is a resident of Chennai. In the year 2022, the father was permitted to have custody of the children for 70% of the vacation on the ground that he had informed the mother he would be obtaining employment in Bangalore. Since then, he has not relocated to Bangalore. He's continuously seeking 70% of the vacations and the mother is left with 30%. Even during this Dasra vacation,
What were you doing till today?
I have filed an application for modification. There's a miscellaneous petition pending. My application for stay had been rejected. Since Dasra vacations are coming out of
Was it
12 days,
rejected?
it was rejected last month, Your Ladyship.
Then what are you doing till now?
The matter came up about a week back. Your Ladyship had directed me to serve the other side. I've served and filed a memo, Your Ladyship.
Because unfortunately, everybody comes
Let's-
to the court just to fag end of the vacation. And we think that some order or the other will pass. But you know, this court will
I'm
not
very
do
well aware.
any of that.
That's not the
kind.
matter here, Your Ladyship.
Yes.
Well, it's one subject.
Just a date may kindly be fixed, Your Ladyship.
Friday.
Huh?
Moved a memo on Friday, my lords, challenging the maintenance order, my lord. Only 26,000 rupees in order. He's working as a carpenter. This matter kindly be taken.
Why it is not listed if office objections are complied? And look at it, if office objections are complied, list it, or else don't list the matter.
Notes. Tomorrow, please, my lord.
Matter settlement.
Tomorrow, please.
If it is, yes,
Matter settlement before mediation center, produce the settlement report. Tomorrow.
huh?
Settle the matter before mediation.
Yes.
Tomorrow.
Well, I'm moving this application for urgent listing. The trial court has passed an order on Friday. This petition is being filed on behalf of the petitioner mother because the 13-year-old child is in her custody. The learned trial court has granted the respondent father custody during Dasara vacation from 29th of September till the 5th evening. Overnight custody. Child has never lived with the father. Mother was mercilessly kicked
When
out.
was this order passed?
I'm sorry, 19th evening, last Friday evening. So which
Office
is about-
objections are complied, list it someday.
I'm sorry?
Yes. If office objections are complied with, then only it will come.
tomorrow. Yes, I will comply. They have also filed KVA. I will say,
We'll see, all matters tomorrow I can't take up.
Manoj, because then they will have 29th is Monday. So if the court vacation will also start on Monday.
What is today? What is today?
Today's
Tuesday. Yes. We have Wednesday, we have Thursday, we have Friday. So on all the days, whenever it is convenient to the court, it will be listed. None of the memos which are given have to come tomorrow. They will come as per the convenience of the court, Wednesday, Thursday, Friday. Adjusted. Yes. Is for the list.
Adjournment. Second list
Take
here.
adjournment. List number 1, page number 3, cell number 10, page number 4, cell number 11, page number 5, cell number 12 to 14, page number 6, cell number 15 to 18.
Serial number 17, my lord. Lordship, I want to place one judgment. Kindly one breathing time maybe next week, my lord, after vacation. The
What is the judgment?
The accident took place in a private place. I have placed some judgment of disarmer court. Your lordship has suggested, inform me to secure the judgment of honorable apex court.
I have the judgment. I have the judgment of the Honorable Apex Court latest judgment.
Private place is
Not covered.
the other one. So that's why, my lordship. Kindly after vacation.
We'll give you the judgment. Please read before the court. So why do we adjourn it again?
1 week, my lord. Only after vacation, my lordship, I will.
We will not either, whatever is the relief, it is today. Yes.
Page number 7, cell number 19.
What is the judgment of Justice Buyon and give him a copy, tell him that citation. Ask Akshita to come. He's aware, I know that. Yes.
List number 2, page wise adjournment, page number 3, cell number 7, page number 4, cell number 11, page number 5.
16, my lord. Settlement is going on.
Lord, serial number
16, my lord. Settlement is going on, my lord. After vacation, my lord.
Who appears as the respondent?
Kapil Dixit,
Informed, my lord. Senior has informed to.
Wherever the matter reaches, then the settlement talks start.
No, my lord.
And they will
Settlement is
stop
going on,
immediately
my
after the matter is adjourned.
No.
This is matter after vacation, not after vacation. This is in the month of December at the request
Lord.
of the council.
Interim order, my
Serial number 19, my lord.
Interim order.
serial 12, my lords.
Serial number 19.
I am for the responding.
I've given copy today, my lord, my land file.
This is matter at the request of the council, the petitioner,
Your
in the
Lord,
month of November.
Your Lordship,
Serial
serial number 22. Your Lordship, seeking for an adjournment. Senior counsel is out of the station and we have informed the opposite counsel as well. I'm for the
This
petition.
also, in the month, the request of the council, the petitioner, in the month of November,
My lord, interim
Okay.
order. 16.
wherever interim orders are there extended. Yes.
page number
Serial number 12, my lords. Serial number 12, my lords. I appear for the respondent in this matter. My lords, our given counsel is undertaking travel, my lords. We've already informed the other side, my lords, may be taken up after vacation.
At the request of the respondent, this is matter, same in the month of November. Yes.
page number 7, so page number 6, cell number 23 to 28. Page
My lord,
number
serial number 24, my lord.
Hmm.
Serial number 24, senior counsel out of session, my lord. Others are informed, my lord. Serial.
This is also in the month of November, at the request of the council, the petitioner.
Represent the petition.
there is urgency in the matter. But it's a case of
But
maintenance.
he's saying that we have already informed.
But they had informed, but
We will hear.
it may be listed after vacation. After vacation. After vacation.
No, it is like whoever is having next roster, I'll be fixing their roster completely with all these.
There is urgency.
It's a matter
Maintenance is delayed.
on 27th of, not 27th, on 29th of October.
Please.
Page number
submission,
7, cell number 29, 30.
Next submission, my lord. Seal number C, list number 2, my lord. See, hearing number 29, my lord. The other day requested the my lord, may be taken up in the chamber, my lord. Your lordship interference may resolve the problem, my lord. At 1:30, my lord.
But today it's not possible. There are so many matters and there is a chamber matter also. Unless
Then-
and until it is listed in the list. What
It's only
about
regarding, my lord, interim maintenance or, my lord, once away, get out of the
tomorrow? Tomorrow in the chambers at 5 o'clock.
normal chambers. My lord.
Tomorrow.
My lord, list 2, serial number 18, my lord.
Serial number?
18, my lord. For the petitioner in this case, kindly have it on tomorrow, my lord. Yesterday,
Tomorrow.
My lord, yesterday I filed an application, my lord. The application was not put up, my lord.
We will call for the application. If you want adjournment, I'll have it in the month of November. Either today or November. Yes. Call for that application. The matters are not listed as a matter of, yes.
Number 3, serial number 1, page number 1, serial number 2, 3, page number 2, serial number 4, page number 3, serial number 5 to 9.
Lord, serial number 7.
Yes,
For the
fine, my
petitioner,
lord.
kindly adjourn the matter, my lord.
Huh?
For the petitioner, serial number 7, kindly any date after vacation. my lord.
Why? Why not today?
My lord, the senior who is representing in this matter is not currently available, my
I
lord.
oppose
That's
for
why
any
requested.
adjournment, my lord, having obtained the interim order, my lord, I neither paid the, nor complied the maintenance.
Here, we'll hear.
Please, ma'am.
Yes, next.
Serial number 9, my
Serial
lord.
number 5, my lord. Serial number 5, list number 3, my lord. My lord, I have received the
Yes.
no objection from the previous council and I have filed it recently, my
Yes.
lord. Hence, may be taken up after vacation, my lord. I have to go through the file as well, my lord. Kindly grant time, my lord.
Serial number 10, your lordship kindly, next week, my lord, some personal inconvenience. Serial number 10, some personal inconvenience, my lord.
Oh,
My lord,
My lord,
serial number 5, my lord.
Serial number 10, petitioner, my lord.
what about respondent?
I will inform you.
No, we'll inform. You have
My
to
lords,
inform.
please,
Wait for your turn. Yes.
Serial number 9, my lords. Senior is having some inconvenience. Kindly have it after
Have you
vacation.
informed the other side?
Yes, my lords.
Does this matter in the month of November?
For
Don't you
My
respondent.
lord, serial number
wait.
5, my lord.
Yes.
My lord, serial number 5, my lord. In list
Yes,
number
what do
3.
you want? Serial number 5.
My lord, I request, I am seeking time for 2
Madam,
weeks.
court is asking what you want in that.
My lord,
Call the list.
am I audible, my lord?
Yes. Yes.
Hello, list number 3, serial number 12, my lords. I am for the petition. I have informed the other side, Mr. Mohan, advocate. Senior is unwell today, my lords.
This also in the month of November. At the request of one council.
I request for the interim order to be extended, my lords.
Page list number
Much.
4, page number 2, page
Yes.
number, page number
My lord,
4,
list number 4, serial number 4.
page
My
number
lord,
4,
2 weeks time may be granted.
Why? 15.
My lord, I filed a application for paper publication. Notice was not served to the substitute service of paper publication. I will take.
When did you file?
Or I will file my next.
One week should we adjourn it? We'll see what is the order of the court. Yes.
Number 13, Malaysia. Serial number 13, Malaysia. By overside, I file a wakalat, other side also, Malaysia. Kindly weak, Malaysia. In
Serial number 13.
connected appeal, Malaysia. Connected appeal, dismissed, already dismissed.
No. Serial number 13.
13.
Ravi Shankar Shastri is there.
Yes, ma'am.
And then
BS.
BS Sachin, Malaysia.
BS.
And one more appeal is dismissed, Malaysia. Is a one appeal. Hence, I filed an appeal, Malaysia. By oversight, mistakenly filed 3 appeal, climate appeal, Malaysia.
so something has to be done with that.
I give you NOC, Malaysia. Hence, I will 1 week, Malaysia.
We'll record it. When it reaches, we'll record it and then do it. Yes.
Page number 6, serial number 17 to 19. page
Serial number 18, my lord.
Hmm.
Kindly obtain after vacation, my lord.
The
I am
list
appealing
is-
for
have you-
the claimants, my lord.
I've informed the other side.
Other side, I have informed.
Is this matter in the month of December? Yes.
Page number
At the
7,
request of non-counsel, the claimant. Yes.
page number 7, serial number 20 to 24. Page number 8, 25 to 27.
Serial number 26, my lords, for the appellant, 26, my lords. For the appellant, my lords, pray for a week's time, my lords. Counsel is unable to appear, my lords.
What has happened? It has come up earlier. Pradeep, 26.
Pradeep, brief for respondent.
Yeah, ready. We'll see. Yes.
Page number 9, serial number 28 to 30.
Yes.
Number 5 for referring to local adalat matters.
Acceptance of.
Court notice issued to appellant.
And then
Sufficient.
the notice is issued to the appellant. What is this acceptance? Paper obligation is given.
No, ma'am, that is court notice sufficient.
What is sufficient? Is issued to appellant and some same is returned with shara sufficient. What is postal shara sufficient? Huh? Who are they to decide it is sufficient? Something will be there. Whatever is the postal shara, basing on that we will decide. All weird things they are doing. From tomorrow they'll say it is sufficient, held sufficient also, they will not decide. As per the office note, as per the postal shara, notice to appellant is sufficient. What is sufficient? Let the registrar clarify that. Yes, next. What about 2?
2 is also
The same. No, that is to the SGJ and JMFC, Banthwal.
this is from SC, yeah.
Let's see.
That's good. This number, fine.
And remaining other matters, refer to Lok Adalat. Except to one and then two also. We'll see later 2. What is that? But it is 3 steps for the conduct of the case. Returned by court notice served personally. Though court notice is served, what is the date? There, next page. There. Monday 2025. As per the report received from SCJ and JMFC, Panthwal, there is neither the claimant has appeared personally nor engaged an advocate. Hence, the list is appealed for dismissal tomorrow. Yes, other matters referred. Please call the list.
In serial number 3.1, also process is not. 3.1.
Let it go, we'll see later.
Awaiting.
Yes.
List number 1. For orders matter, serial number 1, Kumara KG.
Who is the second respondent?
Second respondent is the Malot's insurance. First respondent is the owner. I have to take steps to the respondent number 1, Malot's.
Liability is on whom?
Liability and owner, Malot's.
For issuance of notice.
I may be permitted to take paper publication, Malot's. 2 times I have taken steps.
What happened for the first time? Insufficient address.
Insufficient.
Land counsel with the party appellant is permitted to take out notice by way of substituted service by 13th of October.
Please.
Yes, second,
Till number 2, Kailash Shankar.
same substituted service.
You have taken 3 times steps, madam.
Substituted service.
Madam, I'm filing dispensation. In R1 is already expired before expire.
Take that. A memo is filed stating that. You should have done it long back. Then why are you waiting for these many services? It is submitted that a memo is filed stating that R1, R3.
R3, R only. R1 and R2 only. Madam. R3 is not there. R1 is the owner of the vehicle and R2 is the insurer of the vehicle.
Take out the file. Cause list says R3.
R1 again. 1 and 2 only. R3. R1.
Give the file. First give me that paper.
First as per.
What is happening to these office people when there are 2 respondents? Where is the question of notice to R3?
Others is not claimed for this.
Here it is R3 in the cause list. A memo is filed dispensation of notice to R1, who is the owner of the vehicle on it is, as he remained ex parte. Memo is taken on record and the notice to R3 is the R1 dispensed with the risk of appellant. What is this?
A case of death, my lord.
Take it. Give that.
2016 accident.
2016. How much was taken by the court?
8,000.
8,000 instead of 9,000.
Hmm?
8,000 is taken instead of 9,000.
9,500. What is the age?
25.
Date of action is 2015, my lord, not 16.
15 is only 9,000.
9,000.
Court had taken?
Court has taken 8,000, well.
What is the age?
25 years.
Multiplier?
Multiplier is 18 is
80.
Future
and
prospects?
future prices also.
That has
Only
Only income is.
And how many are the claimants?
mother one.
Mother only, bachelor.
$50,000 is granted more. Love and affection 50,000 and love filial consortium 40,000 is granted.
It's coming to 14,50,800. How much is granted by the court?
13,29,600.
But in this case, the court has granted 50,000 as love and
Okay,
affection.
we are not looking at it. I'm making a recalculation of everything.
9% interest is granted.
For the enhanced amount, 6%.
No,
Please.
that entire amount 6%.
Why?
Claim petition was dismissed against before the MSCTB against the insurance company.
On the ground?
On the ground, the driver is not having a driving license. Therefore, 6%.
Please come. Agreed with award passed in MSC number 1482 of 2015. The claimant is before this court seeking enhancement of the compensation. Also, as well questioning the liability fixed on the owner of the vehicle. The claim petition is filed seeking compensation of an amount of rupees 45,17,000 for the death of the deceased. The tribunal has awarded the compensation as per the table given below at para number 11, para number 9. And counsel appearing for the claimant submits that the tribunal had fixed the liability on the owner of the vehicle on the ground that the driver of the vehicle is not having a driving license, which is a clear violation of the terms and conditions of the policy. Hence, the owner is not liable to pay the compensation. When it comes to the compensation, it is submitted that the accident had taken place in the year 2015, but the court had taken 8,000 as income and granted the compensation, which is not a just and reasonable compensation. Hence, the compensation needs to be enhanced. Then counsel appearing for the insurance company submits that the court had granted the interest at 9% and further on the heads of loss of estate, loss of love and affection, filial consortium, the amount that is granted by the tribunal is on the higher side. Next one. Having heard the counsels on the said perusal material on record. First, coming to the aspect of liability. The liability is fixed on the owner of the vehicle on the ground that the driver is not having a valid driving license. In the light of the law laid down in forensics case, the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. The owner has remained ex parte before the trial court. Hence, a memo is filed seeking dispensation of notice and the same is ordered. Next, coming to the compensation. The accident had taken place in the year 2015. Hence, this court is taking the income at 9,000. 40% future prospects would come to 3,600 and the income is 12,600. As he is a bachelor, 50% has to be deducted. 6,300 into 12 into 18 is 13,60,800 and the head of loss of dependency. 44,000 towards loss of consortium. 36,000 towards funeral expenses and 10,000 in the light of the law laid down in so and so. 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 14,50,800. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 13,29,600 to 14,50,800. The entire amount shall carry 6% interest. The insurance company is liable to pay the compensation and record the same from the owner of the vehicle. There is a delay of IA number 1 of 19 is IA number 1 of, you get that. IA number, do that. IA number 1 of 20 is filed to conduct a delay of 194 days for the reasons stated condoned on the condition. Even in the operative portion of the order also, they are not entitled for interest for that period. Yes, next.
Appeal number 3. Appellant, my lord. This is claimant's appeal for enhancement of compensation. Accident is of the year 2018, my lord.
Case of death or injury?
Injury case.
Please come to the table.
Para 19, internal page number 19, your lordship kindly see. Page number. Para 22, injuries.
Come to the table.
Table is, my lord, para 28.
What are the injuries?
Injuries are para 22, your lordship may kindly see. Communicated fracture of proximal end of right tibia. Post fracture dislocation of right hip. Fracture of left patella. Then lacerated wound over upper lip and other simple injuries.
So there are 3 fractures.
Yes, my lord.
Already 1 lakh is granted towards pain and suffering.
But he was working as a accounts officer in BSNL.
Pain and suffering will not enhance.
But loss of amenities, my lord. Doctor.
Then how many days he was in hospital?
23 days. He has undergone 3 surgeries.
1 minute. You said how many days? 23 days.
23 days.
Medical expenses as it is.
Yes, my lord. Amenities are concerned. Shortening of left leg is there.
So now coming to the loss of future income,
yes,
nothing is awarded.
Nothing is awarded because he was working.
Come to the discussion. Come to the discussion.
Para 24, your lordship.
Please read.
So he has taken voluntary retirement on 31/1/2020, but the accident is of the year 2018. So till 31/1/2020, he worked on that basis. Nothing is awarded for future loss of earning capacity.
According to the doctor, what is the disability?
The disability is, your lordship may kindly see, that is right lower limb 40%, left lower limb 15%, whole body 18%.
40 plus 15 is 65.
Pardon, Mela? Age 55 years.
No, that I understand.
And leave.
He said a whole body is 18%.
Yes, ma'am, 18%. And salary
Loss
was
of amenities, how much is granted?
30,000 is granted.
Will increase on loss of amenities.
And your lordship may kindly see that is laid up period, 3 months he has taken leave.
No, first let's complete loss of amenities. How much? 30, another 30,000. Yes. And then loss of income during laid up period. On what? And because you are getting salary.
He has taken 3 months leave. That is exhibit P10 and 11. Exhibit P12
What
is
was the
joining
salary?
letter. 72,000 is the salary.
But did he use any evidence in that regard?
Yes, my lord. There is, your lordship may kindly see the, yes, exhibit P16 is the
Anybody is
salary
examined? Anybody is examined?
No, my lord. Salary
So which
certificate
year is the accident?
2018.
12,500 into 4. He's taken 2-3 months.
Because 3 surgeries he has undergone, my lord. 55 years old person. He might have taken more than
37,500.
And incidental charges, your lordship.
Which is 23.
No, 23 days. Your lordship may kindly see my synopsis.
No, not your synopsis, sir. It is about what is the judgment saying and what is the evidence.
Doctor is also your lordship. I examined the doctor. He was.
Yes, let's read. Para number?
40. 40 ilve illalla illi.
There is no 40 in this.
There is no 40.
I think you're reading it some other judgment.
Yeah, 32 only para 32.
Only there are 32 paragraphs. Where do you get it from?
Hospitalization, your lordship may kindly see.
Page number?
In page number, in page number 17, internal page number 9, para 19. Para 19. 33 2018 to 21 for 2018. And incident.
Sivanagowda, you're reading some other, it is there. It comes to 2,55,900.
The incidental charges, my lord, only 10,000 has been awarded.
That is, I have granted 23,000. One minute. Liability is on?
50 and KSRTC.
Where do you get the liability?
R1 and 3.
It is not in dispute. The respondent number is the control of KSRTC pass, owner of the lorry, and 3 is the insured of the said lorry.
Last para.
It is also not in dispute. The policy issued in respect to the lorry was in force as on the day. Taken the driver of the lorry was not having so.
Last para. The respondents 1 and 3 are directed to deposit 50% each of the compensation. Accident
2 vehicles are involved.
Yes, my lord. Accident is between KSRTC bus and lorry, parked lorry.
Yes, please come. Agreed with award passed in MSC number 226 of 2018, dated 24 September 2021. The claimant is before this court seeking enhancement of the compensation. The compensation is awarded as per the table given below at para 28. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. It is a case that on 33/2018, when the claimant was traveling in a KSRTC bus at about 11 a.m., when the bus reached near Bimal car showroom, the KSRTC bus driver drove the bus in a rash and negligent manner and dashed the rear side of the lorry, which was parked in the road without any signal. As a result of which, 15 to 20 inmates of the bus, along with the petitioner, along with the claimant, sustained multiple and grievous injuries all over the body. The court had held that there is a contributory negligence on the part of the driver of the lorry, and as well the driver of the KSRTC bus, hence directed both of them to pay 50% of the compensation. Next one, when it comes to the compensation, counsel appearing with the claimant submits that when the claimant is in hospital for a period of 23 days under the incidental expenses, only 10,000 is awarded. It is submitted that when he has sustained 18% disability, the amount that is awarded under the head of loss of amenities is not a just and reasonable compensation. No amount is granted for the loss of owning during the later period. It is submitted that he has taken leave for 3 months and his salary is
72,000.
72,000 and he is entitled for the loss of pay. It is submitted that the compensation that is awarded is not just and reasonable. Next part. Appearing for the respondent insurance company that the court had rightly granted compensation. And there are no grounds to interfere. What about notice to the other two?
Served, my lord. Miss Srimati Renuka appears for the.
Well, I appear for the.
You are representing both.
Well, I am representing CH-18, and we have satisfied the award, my lord.
Counsel appearing for the KSRTC suppressor. They have not preferred any appeal and they have already satisfied their claim. The compensation that is awarded. Next, having heard the counsels on either side, peruse material on considering the injuries, the court had granted an amount of rupees 1 lakh under the head of parents of it. This court do not find any reasons to interfere. Coming to food and nourishment, he was there in the hospital for 23 days, and this court is granting 23,000. Medical expenses, court had rightly granted, no enhancement is required. Coming to the loss of amenities, considering the fact that he worked after the accident and in the year 2020 has taken retirement, the court had granted only for loss of amenities 30,000. Considering the disability of 18,000, the court is granting 60,000. Coming to the loss of income during the later period, though his earning is 72,000, but no evidence is adduced in that regard. Hence, as the accident had taken place in the year 2018, this court is taking the income at 12,500 into 37,500. In the light of the law laid down in Mekala also so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,55,900.
Sorry for the interruption. Permanent disability is entitled, my lord, because there is shortening of the left leg.
That's what is loss of amenities. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,65,400 to 2,55,900. Accordingly, the appeal of the claimant is partly allowed. The enhanced amount shall carry 6% interest. Yes, next.
That's it.
Memo is filed seeking dispensation of notice to R to dispense with at the risk of appellate. Yes, 4.
Cell number 4.
Memo is filed seeking dispensation of notice to R1 and R2.
I filed memo for dispensation.
Dispensed with 1/22 is filed to condone the delay of 6 days in filing. No, that you keep it or condone. Sriram General, you are appearing?
Only quantum is in dispute.
No, you are appearing?
I appear for appellant. Insurance company has also filed an appeal.
Oh yes, 4.1. Yes. Give the file. In MFA 4242, Mr. A. N. Krishnaswamy is directed to take notice as he has preferred appeal against the very same award. Yes. Quantum is only in dispute.
Death of a minor, aged about 15 years.
Come to the table.
25. Para 25, taped page 11.
What is the age?
15 years.
Yes. They want enhancement.
No, I filed for enhancement of the compensation.
How?
That is your lordship, as per the decision of the Honorable High Court, that is division bench. That is taken into consideration, your lordship, the 17th years, 17 at the age of considered as per the income of the, as per the legal chart and additional 40%.
What is his age in this?
Very recently, Supreme Court has held that minimum wages for a skilled labor deserves to be adopted, even for the case of death of minor children.
Death of?
Minor children. If a minor dies, minimum wages that is applicable to a skilled labor has to be adopted.
What are the minimum wages to a skilled labor of that year? Which year is this? 2019.
2019 is, but the year of accident is 2018.
No, 2018.
Minimum wages applicable to 2018.
8,000.
In fact,
8,000.
and collect it and then submit.
And 20 15,000.
18 is.
Skilled labor. That's a distinction.
Skilled.
Here is minor child, aged about 16.
And there is a direction in that judgment so that all the tribunals and courts has to follow the.
Which case?
10 days back it has come up. I will place the decision. My lord, may kindly take it up at 2:30. Or else
2:30.
end of the.
It has?
In fact. Yesterday I was asked to calculate the compensation payable by division bench. I did it. I forgot the citation. Sorry. Hitesh versus.
All the judgments or Kishan Gopal, all are considered in this. Huh?
None of the decisions are considered, but Supreme Court would say. That
No, it is considered in that. Because the other day somebody has shown me some judgment. Is it Justice Sanjay Karol's judgment?
Yes, yes. Sanjay Karol and Prashant.
No, I've seen that no judgment is considered of this Supreme Court. Other judgments are not at all considered. Huh?
In some cases, 2,85,000 is granted.
Not 2 lakh,
Some
like
3
5,30,000 is
30,000 is
Purvan Ansari and Meena Devi. So no, it really it creates a confusion to the courts. Now let's see, where did they say that all the high courts and tribunals should follow? How many judges are there in Purvan Ansari and Meena Devi? Not Purvan Ansari, Kishan Gopal.
2 judges.
Kishan Gopal is 2 judges.
All are 2 only.
All are.
One more. Good. My lord, Para 14 mechanic.
Para?
14. Para 14. As can be seen, there is a great difference between the compensation as awarded by the courts below and the compensation payable as per law. We are constrained to observe that appeals to the High Court as well as.
Kajal's case is it's a complete case of amputation or Kajal's case. Let's take out the judgment in Kajal's case.
Since law need to. Kajal.
Let's see how it is covered by Kajal's case.
It is covered.
Kajal. They have referred to Kajal.
That's what we have the judgment, we'll see. That compilation it is there.
21.
Referred, I saw that. I'm saying let's see what is Kajal's case.
Decision has. Para 14.
No, no, for example, insurance company relies on the judgment of the other cases, Meena Devi and Kishan Gopal. They relying on this judgment, and which has no reference to those 2 judgments, which are squarely on the point of.
Without considering previous judgments, if latter judgment is there, latter judgment is not binding. Only earlier judgment would be binding.
That's why the other day somebody has shown this judgment. I said,
My lord,
take a chance.
Yes, ma'am.
Let us read that Kajal's case. Ask her to give that index. Yes, I know. I saw that. I saw that judgment. Huh? No, what is the where it is reported Kajal's case?
2021.
What is the citation? 2000?
21 it is. Hello.
Take that. 2020. 4. Take that, take the book. In the meantime, she'll get the book. I'll take up the other matter.
Yes.
Yes. Immediately I'll call. Yes, next.
Still number 5. Still number 5.
Who is R2?
R2 is the owners.
2.
R2 is the owners. Liability fixed and the,
Fixed on the insurance company.
no, actually. Yeah, miss.
File a memo.
Please, I will file it now.
Write it and give. What is
Please.
this? We'll decide. Give a
Please.
memo, write a memo and give.
Please.
A memo is filed seeking dispensation of notice to R2 as he was set ex parte before the trial court. Memo is taken on record. Notice to R2 is dispensed with. Yes, come to the table.
Injury of right metatarsal right hand bones.
The table. No table.
Only
The
global
synopsis.
compensation awarded.
How much is awarded?
50,000.
So let's see under the heads. What are the injuries?
Fracture of right.
One fracture.
Yes.
That itself is entitled for 40,000. Let's see. Then how many days he was in hospital?
7 days. 7 days as an inpatient. Doctor assessed disability of 7% to the whole body.
What is income?
Income is 30,000 a labor.
Which year is the accident?
2017.
Court has taken
Globally, not taken any income. So globally, they were awarded.
11,000 into 3. 33,000. Medical bills?
No. No, he's taken treatment in ESI as per there is no medical free treatment.
Then why it is not granted?
No, he's a labor in private. The 3 months has been given.
For the labor, how if he's
He's labor.
daily laborer?
He's taken.
Where do you get that he got a treatment in the ESI hospital? Is it so?
No, he's having ESI card. He's taken treatment because of the accident, not for an ESI. ESI hospital taken. The accident occurred in some other place. He's taken treatment in ESI hospital.
No, this observation is routine observation.
Yes, sir. No, he's an.
Who will get the ESI benefit?
No, he is not getting any ESI benefit. No, medical treatment he is taking in ESI hospital. Because of that reason, he is having ESI card. He is taken free treatment in that
Will be
hospital.
given ESI card.
That-
Anybody who wants to take treatment can.
No. In concerned employer in labor in housekeeping department, they were given the ESI facility.
Then
He's a labor. If you work in that period, they give salary. They were not working, they were not given salary. In a labor in private companies, private in housekeeping. Disability is in a hand labor.
you know, we'll go to with all this, if you go, how a petition is maintainable for claiming maintenance under the Motor Vehicles Act.
No, accident occurred in other place, not in premisal of that ESI. So he is having
You are
a benefit
entitled
of
for all
that
the
ESI. Medical treatment is taken in ESI
No,
hospital.
you are entitled for all the benefits under the ESI Act and you have already availed it.
No, only medical bill. No, there is no other
That is
benefit is
sufficient.
taken.
That is
Only
sufficient.
medical bill they are accepted.
Sufficient.
Yeah.
Under both the acts, how can you come? Either that or this.
Only medical bills. There is no other benefit you taken from ESI.
I'm not inclined. If you want 20,000, we'll grant above that or else I'll adjourn it.
7% is a labor, a fracture of right hand bones is unable to do
Matter
it.
in the month of December. Yes. Have you given the memo?
I'll give it now.
I'll give it. Yes. Admit post.
Otherwise,
finally
consider
recall
1
for-
lakh,
Yeah, huh?
total 1 lakh, please. We are already 50,000 awarded.
IE number 1 of 23 is filed to condone the delay of 1 to 220 days. For the reason stated, delay is condoned
1 lakh.
on the condition that he will not be entitled for interest. Yes, next.
Till number 6.
Please.
80,000. Give that. Come. Agreed with the award passed in MVC number 2537 of 2017, dated 2nd June 2022, whereby the tribunal had granted the global compensation of an amount of rupees 50,000. The claimant is before this court. And counsel appearing for the claimant submits that as per the evidence of the doctor, he had sustained a disability of 7%, and these aspects were not considered by the court. It is submitted that the tribunal ought to have considered the disability basing on the income and ought to have granted a reasonable compensation. Next para. When counsel appearing for the respondent insurance company submits that, considering the fact that he is having a ESI card and he has availed the benefit for under the ESI Act, court had rightly granted a global compensation. He is not entitled for, in fact, the petition itself is not maintainable. The court had granted 50,000. There are no grounds to interfere. Next, for having the counsels on either side, there is a material on record. There is this court finds some force in the argument of the land counsel for the respondent insurance company. However, considering the injuries that is sustained by the claimant and the disability that is sustained, this court deems it appropriate to enhance the compensation, the scope of global compensation from 50,000 to 80,000. Yes. The interest and all, whatever that is there in the order, say. Or if it is 7%, say for 6%. Enhanced amount shall carry 6%. Yes, next.
Till number 6.
Yes, 6.
7.1, all three.
What is this party died? Party.
Party owner of the vehicle, my lord, is necessary party. He died, my lord. I will take steps 4 weeks time, my lord. Liability picks up the owner, my lord.
Liability of the owner is no more as per the postal share, and the appellant will take steps. Of 4 weeks time is granted, default order.
7.1 also. All
Same,
three connected.
7 and 7.1 also same order. Yes, next 8.
Number 8. Till number 8, hearing on interlocutory applications. Shivana Gowda.
Yes, Mr. Shivanagoda. What is this? Huh? Huh? Pay and recover order has to be. Huh? Pay and recovery. Which one? Huh? That's the, no, it is. Yes. Huh? What are the vehicles that are involved in the accident?
Bike.
Hmm. Switch on your mic. Switch on the mic. Yes.
Charge sheet was filed against one Kiran Nayak, son of Obla Nayak, resident of 10 Second Cross, Guttalli, Mandya. But that is the driving license which was produced before the court. But charge sheeted driver is only Kiran, son of Obla Nayaka, resident of Jayanagara, Olevannuru, Bhadravati Talak, Shivamogga. The DL which was produced not belongs to the charge sheeted driver.
What was the finding of the court on that?
Court says that Malad. 1 second.
So because change of address, name and everything is same.
No.
Change of address is there. You say that it is not. It doesn't belong to him.
No, Kiran Nayak and Kiran.
So that's
Kiran,
only ground.
That is the only ground, ma'am. Kiran Nayak and Kiran. So two different.
Photo must be there. Driving license photo will be there.
Correct, Malad. Kiran Nayak and Kiran are not the both are the
photos are one and the same or not?
No, it is not, photo is not in the charge sheet, my lord.
Not
Only in the
charge
driving
sheet,
license it is
then
there.
Then the burden lies on you. You can produce both the licenses and show.
Driving license.
Yes.
Driving license, the charge sheet driver is Obla Nayaka, Kiran son of Obla Nayaka, some address. For that, my lord, they have not put, they have not produced the driving license, that person. Normally, what will happen, my lord, the police, during the investigation, my lord, after address, getting the information only, they will collect the driving license. And they will mention the charge sheet. According to that, this is the address they have given. But the driving license which was produced before this court is Kiran Nayaka, son of Obla Nayaka.
So you will only take a clue from what they have produced. You will not take any effort.
They themselves produce the driving license.
It was a very simple exercise. According to them, both the Kiran are one and the same. You say that this Kiran and that Kiran are not. Then simple. You should have called for the driving lessons of the RTO. You could have called for, and you have showed.
RT officer is not examined.
In this case, my lord, the driving license itself produced by one belongs to the Kiran Nayaka.
I say when you're taking, when that's your stand, you should do something to prove it. Except relying on some this thing in the charge sheet. That's what the insurance company does. You will only rely upon the documents filed. You will not take any steps. Now, what are that? Copy of the complaint, copy of the inquest, police statement, PM report, charge sheet, RW1, authorized letter, extract of DL, extract of DL. R2, R3, please give.
R2, R3 and R6. Maybe.
Let's see. Someone, who is Ananda?
Ananda Manoj is.
What is the name of the claimant?
Pardon?
What is the name of the claimant?
Jayamala Arshad.
It's a case of death.
Death, my lord.
Mallikarjuna is a deceased.
Then who is this Ananda? Exhibit R1 is Ananda. Ananda's driving license.
A rider of the motorcycle.
Next, Ananda NK. Kenche Gowda, son of Kenche Gowda.
That is a rider of the motorcycle.
Where is this exhibit R6? Girisha K. So, nothing is there on record. Except you don't do anything except relying on the charge sheet. Once it is Kiran Naik. So that's how there is no driving license. That burden lies on you. Yes, next.
No, the police said during the investigation, they will collect the driving license. Based on that, my lord, the charge sheet will be filed. At the time of collecting that information, according to that, my lord.
Both are Kiran.
Kiran Nayak and
wrongly mentioned earlier.
My lords, may I pass on
that has
one
to be
judgment?
clarified.
Squarely covered, man.
That has to be clarified by the investigating officer.
You also should do something in insurance company,
except remand the matter,
writing
general
counters, general denials,
May I
and
lead,
keeping quiet.
May I read, my lords?
Yes.
Para 16, my lords. As already pointed out, Supra, once a seemingly valid driving license is produced by a person employed to drive a vehicle, unless such license is demonstrably fake on the face of it, warranting any sensible employer to make inquiries as to its genuineness, or when the period of license
So how
is
does
already.
this will come to your rescue? It is about the driving license, whether it belongs to that person
He is the
or
owner
not.
of the vehicle.
Because they are taking that.
You are the owner. Huh? He is the owner, but he is the owner of the vehicle. Let him produce the charge-seated driver license, my lord. That was not placed
Burden
before
of
the
proof
court.
lies on them to disprove that, to prove that I have not taken necessary steps to.
Oh, you are contesting. You are contesting. Why don't you prove? Why don't you place before the court the driving license?
Please, my lords,
And
I'll
counsel,
write.
the counsel appearing for the owner shall place before this court the driving license of the charge-sheeted driver. And also, with regard to the discrepancy in the charge sheet about the charge-sheeted driver and the driver where the details are not matching, that also should be clarified. This is matter immediately after vacation.
Serial number
Yes.
9, TJ Chunkapur, Paraplegia, Anup Sita Ram Rao.
Yes,
Case of death, my lord.
there is the Anup Sita Ramarao.
I'm representing.
Yes.
Minor child, my lord, 4 years of age, my lord.
My lord, I was exonerated on the ground that, my lord, accident occurred in Davangere district. The permit of the vehicle is applicable only to Shimoga district.
Pay and recover.
Pay and recover, my lord.
Internal page 12, paragraph number 15.
Then what about the compensation? How much it is granted?
Compensation, page number in
5,010. Then we will take as per that. You are also relying on this judgment.
Yes, my lord.
4 years.
Yes, my lord.
Pass over.
Please,
So
ma'am.
that judgment you call for that Kajal's case.
Kajal case, 2 judges.
Give it.
judgment, my lord. Yes.
Two
But
judges.
2 judges, what is the law laid down in that? Let's see.
My lord, paragraph 20.
It is a vegetable condition.
That's what
Vegetable,
Kajal.
that has
And
to be
one more
the
one more
distinction, my
judgment
lord.
is Kajal and
No.
there's another judgment of K or some. That also because they were in a
They
vegetable
are
state
the vegetable
of.
condition.
So that will not
case
apply to
is
this
not
case.
universally applicable to all injury cases.
Correct. There the court has considered that throughout the life they require medical
Attendant
assistance.
also and all.
That's how all those things were considered. Kurvan Ansari. Kurvan Ansari, Kajol are all under, they stand on, it's not a case of death. It is a case of
Injury.
fatal injury, paraplegia or something. That's a case. How can it be applied to the death case? And that too, the judgment which is referred with the Honorable Apex Court doesn't lay down any law on that.
Recently, my lord, Kerala High Court have given some judgment, my lord. I place it.
No, the problem is Kerala High Court.
death
No,
case, my lord.
Kerala High Court, Karnataka High Court, Madras High Court. That's not the law. There should be some uniformity. We cannot do injustice to the litigants like this. There should be some consistent view. So we have to take the view that is taken by the Honorable Apex Court. Till recently of this judgment, we are following the judgment of Kurvan Ansar, not Kurvan Ansar, Kishan Gopal and
Kishan
Meena Devi's judgment we are following. Now, when there are 2 judgments on that line, this latest judgment has not followed those 2 judgments, number 1. Number 2, the judgment that is followed, that already the law is settled, is altogether an exceptional case of Kajal and Kurvan Ansari. So it is like, it unnecessarily creates confusion.
Not 5 lakhs can be granted, my lord.
Huh?
5 lakhs can be granted, Kishan Gopal's case.
No, but he has to be 5,30,000, I think, in Meena Devi.
525.
But I am not inclined to apply this judgment because it is not, because that is, we have to only look at the other 2. If we understand the latest judgment as considered the earlier judgments of the Apex Court on the same, and if they have taken a different view, then it's a different issue. Court has not at all considered. Relevant judgment is Kurvan Ansari and Kurvan Ansari and Kishan Gopal are the relevant judgments for this. If you want, I can adjourn, but I can't. I cannot pass because there should be some consistency from the orders that are being passed by the court, basing on the Supreme Court judgment.
Please.
Huh?
Please,
What is that? Actually, adjourn.
no, pass the order.
Pass order. Like Meena Devi, how much it is? Meena Devi and 5,30,000, I think. Let's take that. Give the judgment.
It can be disposed of, he is giving consent for that.
No, court has no objection. If he feels that he can take a chance, he can take a chance. That's what I'm indicating. It's there. First, in the first list only it's there. Give that list. Index it is there. Kishan Gopal is here, 72 to 85. Meena Devi is at 223. 222 to 231. 72 is Kishan Gopal. 72 to 85. Take 85. But rate of interest is 9% in these judgments. That we will grant. 4 lakh 50 plus 50, 5 lakhs in this. And in Meena Devi it is 530.
530.
I think.
525, Milord.
We will follow Meena Devi. Meena Devi at 223. No, in this also 5 lakh. Where did I see 5 lakh 30,000? In one judgment it is 5 lakh 30. It's 5 lakh 30. Where is Purvan Ansari?
Kishan Gopal, 5 lakhs.
Purvan Ansari, it is in
It's there.
359.
Purvan Ansari is only 3 lakh 75, 4 lakh 70,000. So we'll go with this 5 lakh. Two? In Purvan, this is a case of death of 7-year-old. But the court had granted only 4 lakh 70,000. Then maybe enhancement of the compensation. Land counsel appearing for the respondent, appearing for the appellant has granted the compensation as per the table given below. Next, the court has granted the compensation as per the table given below at paragraph number 14. Then counsel appearing for the claimant submits that the court ought to have taken the notional income as per the judgment of the where is the judgment? Now they have passed on. Latest judgment. Even
Madam.
take that.
Take not.
Relying on the judgment of the apex court in Hitesh Najibai Patel versus Bababai Najibai Rabri and another, arising out of SLP civil appeal number 100278 of 2025, where the court had considered the notional income at
Para 13, my lord.
had taken the income at
Lord, they applied second schedule, 163A.
as per the 163A and granted the compensation. It is submitted that in this case also the same needs to be applied. Then counsel appearing for the insurance company submits that in the light of the law, when it comes to the death of a minor, the Honorable Apex Court in Kishan Gopal and another versus Lala and another reported in 2014, 1 SCC 244, has granted compensation of an amount of rupees 5 lakh. And also later in Meena Devi versus Nanuchand Mehto, reported in 2009, 14 SCC 1, Kishan Gopal is 2014, 1 SCC 244, had granted 5 lakh rupees. It is submitted that in the present judgment that the petitioner is relying on, the appellant is relying on, the judgment of the apex court in Kishan Gopal as well as Meena Devi was not considered, and only a case in Kajal's case was considered. Kajal's case is a case where because of the accidental injuries, the claimant is in a suffered the paraplegia case. Is it? With paraplegia, and she is completely in a vegetable condition. Looking at those circumstances, the court had granted the compensation. It is submitted that as this judgment has not considered the other two judgments which are on the relevant point, this judgment is not applicable to the facts of the case. Next one. Having heard the counsels on either side, there is a material on record. This court finds force in the argument of the learned counsel appearing for the insurance company. In the latest judgment of the Honorable Apex Court, the two earlier judgments in Meena Devi and Kishan Gopal were not considered. And Meena Devi and Kishan Gopal squarely applies to the facts of this case. And in the light of the same, this court is inclined to follow the said judgments and grant a compensation of an amount of rupees 5 lakhs, and the interest at 9%.
9%. Liability pay and recovery.
The next, coming to the liability, the court has fixed a liability on the owner of the vehicle on the ground that the driver on the ground that the owner
Permit is.
there was no permit where the accident had taken place. Even if there is violation of terms and conditions of the policy, in case of permit also, as per the judgment of what is that, Rani versus
Amritpal Singh and Tata AG.
Pappu. In the light of the certain law, still the insurance company is liable to pay in the light of the law later on in Rani and others was a national insurance company reported in ER Online 2008 SC 84. Still the insurance company is liable. Hence, next, passed over matter.
The entire amount can be released. Entire amount can be released.
Yes, the entire amount can be released. Yes, next. Where is Mr.
Still number 4.
In the other case also have applied the judgment of Meena Devi and Kishan.
In this issues, the Supreme Court pending before regarding taking to notional income, that is pending.
That's what we'll adjourn it. I'll not pass any order if you want. Yes, adjourn this matter after vacation.
After vacation.
Yes, next.
Still number 4. Still number 10. Still number 10. Krishna
Yes.
Kishore.
Lord, my appeal is on 2 grounds, my lord. Lord, after adducing the evidence, I filed application before the tribunal to produce the driving license of the driver, my lord.
He's not having a driving license.
He was not having
What
driving
did the
license.
tribunal do?
Lord, tribunal did not direct pay and recovery. Internal page 21, ink page number 28, my lord, with regard to liability.
Internal page 28.
21, my lord. Ink page 28, my lord.
Yes.
Paragraph 43, my lord. It is an admitted fact that respondent number 1 is the owner and respondent number 2 is the insurer of the offending vehicle. It is also admitted the fact that as on the date of accident, policy was in force. Though the respondent number 2 contended that offending vehicle was not insured and the driver of the offending vehicle had no driving license at the time of accident, it is not produced any documentary evidence. Therefore, respondent number 1 and 2 being the owner and insurer of the vehicle are joint and severally. However, second respondent
So
insurer.
where is that IA?
No?
Where is that IA of yours and where is the discussion?
Lord, after I adduced my evidence.
What did you produce?
My lord, we have stated that he was not having driving license. Therefore, a direction was sought by the tribunal to the owner to produce the driving license.
Who appears for the owner here?
My lord, I am the claimant. My lord. He is the claimant.
Then apart from the owner, you should have taken some steps. If you say that owner is
It
liable.
is not done, my lord, and Odd 8 Rule 12 CPC application was filed. In spite of that, he has not produced, my lord. Therefore, at least pay and recovery order could have been made, even that.
He has not contested there. Has he contested before the tribunal?
R2, yes, my lord, contested. Contested. We filed.
Or what about this court?
Owner. He appeared, my lord.
No, before this court, where is the notice to him?
That is, one is Srinivas V for R1, R2
Krishna Kishore for R2.
R2 served.
Then what about notice to the owner? If you say in your appeal
My lord.
that owner is liable, pay and recovery has to apply, notice is served. Baswaraju.
Baswaraju, my lord. My lord, he filed a statement of objections also before the tribunal.
Yes. Then what about the compensation?
My lord, I am not on quantum, my lord.
Huh?
I am not on quantum, only one ground, my
They
lord.
also
9%
filed
interest.
appeal. They filed up. That's
Cross
right.
objections.
Yes. So
My
let's
another ground
see
is,
the-
my lord, 9% interest is awarded.
That we will see. Yes, please come to the table. What are the injuries?
My lord, I am on the quantum, my lord. My lord, the
Page
injury.
number 19, my lord.
In page 19. What are the injuries? Where do you get the
My lord,
injuries?
lacerated
Paragraph
wound
24.
of forehead.
Paragraph number?
24.
Yes.
Lacerated wound over forehead on the left side of so and so. Lacerated wound over left cheek. Multiple abrasion over both bands, red and tender. Fracture of left
So one
traverse.
fracture, 2, 3,
3,
4,
4 and
5,
5 also,
6,
my lord. Yes.
6 fractures.
Not
Yes.
5, my lord.
What did the
Pleural
court grant?
hematoma.
Huh.
Hematoma.
No, that we have not got. The 10th one I have not calculated. I have not counted 10th one.
From 4, 5, 6, 7, 8, 9.
4. Here there are 4. Here there are 2.
Yes.
Yes, my lord.
So
My lord,
altogether 6.
it was a head injury also. 34, my lord, is the page from paragraph number
Yes,
34.
we will grant another 20,000. Then medical expenses as it is.
Inpatient yesterday.
1,74,000. How many days was in hospital?
My lord, he was in hospital for about
3 days. my lord.
3 days, total for a period of 3 days.
The court had rightly granted. Nothing to increase in that. Next, loss of income during later period. What is the income according to you?
My lord, 6,500, the trial court have taken, it should have taken 9,500. 2016 accident.
27,000. Then, what is the evidence of the doctor with regard to the permanent disability?
My lord, he's paragraph number, that's what I was taking your lordship's, my lord, it was a head injury. He has clearly stated that he is unable to study, walk, and he cannot stand steadily. That's why I was adverting your lordship's attendance to paragraph number 34, my lord. CW1 further stated that on, may I, my lord? CW1 further stated that on being followed up, the continues to complain of imbalance, heaviness in head, reduced memory, and difficulty in comprehension. The petitioner feels unsteady in standing and walking and is unable to drive vehicle as he is afraid of imbalance and unsteadiness along with the reduced movements of right forearm. CT head on 21/8/2000 shows hypodense lesion involving right anterior temporal lobe, suggestive he was last seen on 21/8/2018. So now, my lord, you know, 25 total disability, it has taken 40%. Now, my lord, since it was a head injury where balance issue is also involved, I request that 40% be taken for
Court
this.
had taken how much?
My lord, the court have taken, my lord, it has 48. It has taken 48%. Total physical would be assessed by 8% and 48% it
No,
has
when
taken.
he has assessed the disability, he has assessed the disability because of the injury to the head.
Head, my lord. And physical disability also there.
Where do you get it?
My lord, at paragraph number 39. 39. As stated supra, the petitioner has not documentary evidence to prove his monthly income. In the absence of documentary proof per month is taken to determine the loss of capacity of a permanent. As per PW, the permanent physical disability towards right upper limb was assessed 22%. Normally 1/3 of the above mentioned is shown. 48% it has token prop.
48% is considered.
48%.
48% is considered. Income has to be changed.
Income has
40% is already considered.
yes, 48% is already.
Huh?
Yes, madam. It has
40 or 48?
48 it has considered.
40 plus 8, 48
40
considered.
plus 8 it has 48 it has
Income
considered.
considered is 6,500.
6,500 considered.
So 9,000 into 12, what is the multiplier?
9,500.
16
I think it's 9,500.
9,000?
9,500. 2016 accident.
Oh, then 9,500 into 3. Comes to 28,500. So 9,000, then we have to take future prospects. So what is the age?
42 milord. 42 at the time of accident.
Then 25% future prospects.
Yes, that has to be taken.
9,000 plus 25%. 9,500 plus 25%. It is 2375 plus 11,875 would be the salary into 12 into what is the multiplier?
16. 16.
16 into 48 by 100. It's coming to 10 lakh 94,400.
5,99,040 granted. 5,99,040 granted.
Then what are the other heads? Then coming to the loss of amenities.
40,000 is granted.
But it is 48% disability.
No.
We'll grant another 30,000.
Sir.
Future. Future medical expenses in Kutel.
Doctor ಏನು ಹೇಳಿಲ್ಲ.
Future medical
Doctor ಹೇಳಿಲ್ಲ. ನೋಡಿ.
Doctor ಏನು ಹೇಳಿಲ್ಲ. Since it was a future. Future medical expenses, nothing have been paid. Doctor have not stricken anything. Future medical expenses.
No, my lord, doctor has not.
So there should be some evidence for that.
No, my lord, they have assessed only disability. Both doctors.
It's coming to 17 lakh 37,825 against 9 lakh 16,465. Please come. Agreed with the award passed in MBC number 438 of 2017 dated 31st July 2020. The insurance company is before this court but filing the appeal. In that, the claimant had filed MFA crop seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 42. Learned counsel appearing for the insurance company submits that when it is a specific case of the insurance company that the driver of the vehicle is not having a valid driving license, and in fact they have filed an application asking the owner of the vehicle to produce a document. In spite of the same, he has failed to produce the same, and the court ought to have taken an adverse inference and ought to have held that there is no driving license, and the court ought to have fixed the liability on they should have applied the principle of pay and recover. Then the land counsel appearing for the claimant submits that the compensation that is awarded is not a just and reasonable compensation.
5.
It is submitted that the claimant had sustained as many as
10 injuries. 10 injuries.
6 injuries, 6 fracture injuries, and court had not granted a reasonable amount under the head of pain and suffering. It is submitted that as per the evidence of the doctor, he suffered 48% disability to the whole body. In that case, court ought to have taken the future prospects at 25%. It is further submitted that the court had taken the income at 6,000.
6,500.
6,500. As this is an accident of the year 2016,
16.
the court ought to have taken 9,500. It is submitted that the compensation that is awarded is not just and reasonable. Next, for having heard so and so, so and so. Then in council, this court has perused the award and the compensation that is awarded at different heads. Considering the 6 injuries, fracture injuries he has sustained under the head of pain and suffering, this court is granting 1 lakh. Medical expenses and the food and nourishment, court had rightly granted. No enhancement is called for. Coming to the loss of income during the later period, 9,500 into 3, this court is granting 28,500. Coming to the loss of future income, court had both the doctors have given a consistent evidence and he had sustained 48% disability. As this accident is of the year 2016, this court is taking 9,500. As the age of the claimant is 42 years.
Yes, ma'am.
Future prospects at 25% would come to 2,375. Then the income is 11,875 into 12 into 16 into 48 by 100 is 10,94,400. Loss of amenities considering the disability of 48%. This court is granting 70,000. In the light of the law laid down 10,000. Altogether, the claimant is entitled for an amount of rupees 17,37,825. Accordingly, the appeal is partly the appeal that is filed by the insurance company is allowed in part by applying the pay and recover, and then the MFA crop that is filed by the claimant is allowed in part by enhancing the compensation from 9,16,465 17,37,825. In their appeal, it is partly allowed by placing that and also reducing the rate of interest from 9% to 6%. Yes.
Cell number 11. Cell number 11.
And for the appellant in all the 5 cases, my lord. This is the case of injury, my lord. They have filed the claim under 163A. The tribunal has ordered in 164, my lord, which was effective only from 1st September 2019, my lord. The accident is of 2017. That is what we have challenged it, my lord.
What do you say on that? Huh? Yes, you can argue.
Yeah.
You can argue. Please come to MFA 3241.
I think we need some records also, my lord, because all the injury cases.
Please give that.
I don't have the records right now.
Huh?
I don't have the records right now. Records bandide, madam.
Ide.
Madam, this is also covered by your lordship judgment, madam.
Take that.
Both are passed, my lord. Those are the death cases, my lord.
Prior to amendment, what is the amount?
2,50,000 they have granted in all the 5 cases, my lord. Injury cases as per 164. So we have challenged it because it was not effective at the time of the accident.
So what it should be?
My lord?
Then what are the amounts that they are entitled?
They are entitled as per the schedule, my lord. 163A schedule. Whatever injury says there, as per the schedule, it has to be granted.
Let's see. Take the schedule. So MFA 3241 is arising out of, at least you should have made a table for this.
My lord,
MBC, we should have made a table for this.
the table is there, my lord. I have a copy.
Give that, take that. 163 a schedule, what are the so I'm asking about these MBC numbers, sir. MFA 324 arises also of MBC 3839. So what are all the, what is the
Injuries.
award? Come to the order.
3239, my lord.
3839.
It's not 38, my lord.
That's what your appeal is showing.
Appeal number is 3239 is the first appeal.
MFA 3241 arising out of
3249.
MBC 3839 of 2017.
Alala, 3839 MEC. MEC ಹೇಳ್ತಾರೆ.
No, the file that is given to me is MFA 3241. That is arising out of, as per their own appeal, it is arising out of MBC 3839.
My lord, in 3839, they have suffered injuries like fracture of shaft, left femur, fracture of left femur, leg, and fracture third and fourth metallurgical left foot, and fracture of left shaft of left tibia and other injuries, my lord. As per the wound certificate, my lord, they say that it is all simple injury. The doctor has given
So 40% to the right limb and 20% to the whole body.
Yes, ma'am.
33% to the left limb and 16.19 to the whole body. Total whole body disability is taken as 36%. 30,000 towards conveyance, so and so. So coming to the table.
As per the table, my lord.
What is the age? Three 839 age is 24 years. 24 years as per the table.
Into multiplier.
Multiplier is 17. What is this? Next, look at the table. You're passed on.
I don't have only one copy. I brought it. Madam, table there. 163A. Book kalli there.
Please do some exercise and come back. This is not for the court to do all this.
Lord, I brought this thing, my lord. Table.
Pass over. By the time I want a table. We will not do the exercise like this.
Cell
Yes,
number 12.
Madam.
Cell number 12.
Madam. Table.
records is sent back.
Table.
We will decide the appeal. No, the sending back the records, getting it back. Yes,
No, it's already sent.
Of the injury.
We'll see. Yes.
It's a case of the injury, my lord. The appeal by the KSRTC challenging the quantum of the compensation on the basis of the assessment of disability. My lord, in this case, my lord, the doctor has assessed the disability of upper limb 9%, lower limb 16%. So particular part disability 24%. Court should have taken 1/3, my lord. Here, my lord, the court has taken the entire 24% as a disability.
So 16 plus 9 is 25. 25.
Yes, my lord.
But 25 should be 1/3 of 25.
Yes, my lord. 1/3 should have taken.
25. It comes
24,
to
24.
8.3.
24. 15, 9. Oh, sorry. I apologize. 25.
It comes to 8.3.
Yes, my lord. It has taken the 24%, holding that too, my lord. There is an error saying that doctor has said 16% is the lower limb. In its judgment, he has said lower limb itself 24%. And presuming that he is the driver, he might leave his profession at future. It has taken 24.
The table.
Milord?
Table.
That is not so, my lord. That is why I am making. That is not so. Doctor has assessed the disability by using the telescopic formula and come to the proper conclusion that one limb after the assessing disability, it comes to 16% to whole body. And another limb, my lord, after evaluation of all the disability and adopting these telescopic formula, it comes to.
Let us read the evidence. What is this special
No,
formula?
I have doctor evidence, my lord. I have doctor evidence. It runs to.
Read.
Milord, may I request your lordship to peruse the evidence of PW1?
Yes.
Sorry, PW2.
PW2, total 5 pages of only assessment of disability. 5 pages of affidavit.
Let him argue, it is his appeal. Yes.
Let me read, my lord, the relevant portion of the judgment in which the honorable tribunal has
Come to
arrived at.
that. Point out.
May I request your lordship to peruse page number 9, ink page number 16 of the appeal memo,
Yes.
para 18.
Yes.
As per the evidence of PW2, the petitioner has disability of right lower limb
Please
24.
refer to paragraphs. There are only in page 16 is the pain and this table.
In judgment,
Paragraph number
18. In page number 6 of 9 of the judgment. Internal page is 16. Judgment,
I'm looking at judgment only.
Page 9 of the judgment.
Please read.
Para 18.
Yes.
Yes, I'll come to fourth line from the top. As per the evidence of PW2, the petitioner has the disability of right lower limb but 24%. In fact, my lord, doctor has assessed only 16%. Here he has taken 24%. For a driver, right leg plays a prominent role in driving a vehicle. A driver operates a clutch and accelerator from the right leg. So the permanent disability on this right lower limb certainly affects his job. Due to disability, the petitioner certainly feel difficulty in applying the brake and accelerator. The disability may force him to quit from the driver job. Therefore, I assess the functional disability of the petitioner of 24%. And in fact, doctor himself says there is no difficulty in performing day-to-day activities in his evidence. May I request your lordship to peruse the
Day-to-day activities also includes driving.
Yes, my lord, he says that there is no difficulty. In fact, in his evidence.
So, no, you're saying that what is the disability to the right leg?
Right leg is 16%.
Left?
That's all. 16%, and right limb is that is 6%. Sorry, 9%. So here, court itself has taken 24% as
Disability to the right hand is 9.
Yes, 9.
And right leg is 16.
16, 16. The court has taken 24 all over leg itself. It has taken 24 and presumes that there may be he may leave.
So he wants to rely on PW2's evidence. Read what is that?
Yeah, PW2. No, he has assessed the disability, my lord. So, thus the total amount of disability to the whole body from the right lower limb is 16%, he says. He gives full body disability whenever there is. Before that, he explains the deformity, the additional points what he has explained. Deformity in functional position, 3%, deformity in non-functional position, pain.
So what is the disability as given to the limb in the calculation?
No, maximum 10% only. For added points, total permanent physical disability to the whole body from the right limb, right lower limb, it is 16%, he says. That's all.
He doesn't assess the limb disability particularly.
No.
16%. 16% what he's saying is to the body.
Now, whole body, how can he, my lord, he specifically assess, my lord, for a particular limb by assessing whole body, he says. It's a particular limb.
Then we'll set aside this award and you examine the doctor again.
And in fact, on contrary, this honorable tribunal has taken 24% for the whole limb itself, lower limb itself.
Yes, Mr. Shastri.
Malad, it is not at all what my learned friend arguing. Malad, kindly see the doctor's evidence. Malad, doctor assess the disability from the loss of movement and muscles power and also additional points. Malad, thereafter, Malad.
The doctor, Mr. Shastri, what is the limb disability first? Then what is the whole
Malad, first for movement loss it is 6%. Malad, thereafter, Malad, 6% loss of mobility components. Malad, the stability components, Malad, 9%. Malad, thereafter 14%. Malad, thereafter, Malad, additional points. Malad, doctor specifically stated in his evidence, thus the total amount of disability to the whole body from the right lower limb is 14 plus 2, 16%. Malad, each and every disability parts is evaluated, and thereafter for
doctor has not anyhow stated, and you are also not answering to the court's query. I said it's a duty of the doctor with that great calculation first to arrive at what is the disability.
Yes, yes, he done.
That's what I'm asking. What is the number?
Malad, it is runs into pages. Malad, if my learned friend have the doctor evidence, it is better to explain it. It may be easy for me to explain because there are the 4 pages only for assessment of disability.
Whatever it is, he has to let him give 10 pages of the evidence. It has to be clear. What is the
hip, Malad, active range of movement, Malad, that is comes to that disability maximum is 90%, hip 30%, flexion 0 to 140 degree, 0 90 degree, and 90% degree. Malad, further, Malad, knee 30%. Malad, this 125 degree. 100 degree he lost the 25 degree movement in as far as knee is concerned. It comes to 3.6%. Thereafter, ankle and foot, well, he does not lost anything, so it comes to 6 total loss of movement, hip, knee, and ankle.
It is not for you. It is not for you or to the court to make this kind of calculation. It is for the doctors to say.
Yes, my lord. Yes, that is why I am submitting. That is why.
Where is the number? He has to say this is a limb disability.
Yes. He done, my lord. That's why I am. If my lord has
only one, all that reading not necessary. Tell the court what is that number, what is the whole body, what is a limb disability. That's what I'm asking. You don't have to read all this. He has to tell, based on his calculation.
My lord, the whole body right of limb C plus, my lord, he bifurcated that is why I am repeatedly telling, if my lord have the copy of doctor evidence, my lord, it may come to my lord's knowledge how he has calculated. My lord, see, he adopted these telescopic formula first, my lord. That's why records may be necessary, my lord, for this.
Agreed by award passed. Number 7.
One submission, madam. I want to make my submission, my lord. I want to make submission.
I want only first, Mr. Shastri, please tell the court, as per the evidence of the doctor, what is the limb disability. I will not calculate. I will not calculate. I want the doctor's evidence. Only on the point straight. Straight on the point. This is the limb disability and this is the functional disability. This is a whole body disability. Was the doctor's evidence is clear on that? We will not calculate.
Clear, my lord, clear. That is why, if my lord have the copy of the doctor evidence, if my lord see the doctor's evidence, my lord,
Yes, I understand.
And one more thing, my lord, in
No,
this
no,
cross
it is not
examination,
14% to limb and 6% to whole body.
Doctor specifically says there is no problem in hip and knee.
No, my lord, it is.
In cross examination.
My lord, may kindly see the doctor's evidence or my submission may be taken on record. My lord, it is not 14%.
I will record your submission.
My lord, I will explain how we have calculated the disability because it repercussion is.
The doctor should be self-explanatory.
Yes, yes, it is. Yeah, my lord, first assess the loss of movement of hip, knee, and ankle.
Wait for a minute. I am asking you one straight question. I do not want to read and count. What is it? Is it the doctor's evidence clear on in one sentence by a definition?
Yes, it is clear. Yes, it is clear.
What is it? Tell the number.
My lord, my lord, loss of movement of hip resulted in 6%. My lord, the loss of.
Not calculate all that. What is the evidence of the doctor? This is whole body disability. This is limb disability. If it is not there, I will send it back. I will send it back. I will remand it back. Let the doctor give the evidence on that.
Yes,
you are not understanding that. That's what the court
no,
is going
I understand. Because my lord has no doctor's evidence copy. My lord,
whereby the court had granted, the tribunal had granted compensation of an amount of rupees 9,43,834. The corporation is before this court. Land counsel appearing for the corporation submits that the court had considered the disability at 24% to the whole body when it is evidence of the doctor that there is a limb disability of 16% and there is a right limb to the right leg 16% and to the right hand 9%, which comes to 25%. It is submitted that the court had taken the disability to the whole body to at 24%, which has to be 1/4 of the whole body disability. It is submitted that the court had to fail to appreciate the evidence by the doctor. Next para. When counsel appearing for the respondent claimant submits that the doctor has scientifically done the evaluation and has held that the whole body disability is 24%. And there are no grounds to interfere, and the court had rightly granted compensation looking at the evidence of the doctor. This court has produced the order that is passed by the tribunal. And the evidence of PW2, the doctor reveals that he has assessed the different components. He is a technical person. That is not for the court to count all those components and say what is a whole body disability, what is the limb disability, then what is a whole body disability. First of all, it is the duty of the doctor to specifically say what is the limb disability. Admittedly, in this, except making the calculation, he has not stated what is the exact limb disability. When it is not stated why the court had taken 24% as a whole body disability, this court is not able to appreciate. In that view of the matter, the order of the tribunal is set aside and the matter is remanded back to the court only to assess the disability, only to examine the doctor and place evidence before the court with regard to the limb disability and which led to functional and whole body disability. Accordingly, the appeal is, the order is so and so, award is set aside and the matter is remanded. Without further notice, the party shall appear before the court on 28th within 2 months from the date of the receipt of the copy of the order. The tribunal shall dispose of the matter. Yes, next.
Number 13, final hearing, Narendra Gowda for petitioner.
The amount in deposit shall be forthwith transferred to the court and shall be kept in a fixed deposit.
Appearance date, my lord, 28?
28/10, sir.
Yes.
It's a case of injury, my lord.
Narendra Gowda.
I have produced the EA for production of additional document. After the disposal of the claim petition,
For
he
what
has taken the treatment and his
Medical
entire
records.
Have you seen that?
medical
Additional medical records are produced, my lord. Evidence is required.
and his
Doctor
entire
has given
right hand was crushed. He is present before the court and his entire right hand was crushed due to the injury and his left hand was.
How much you are seeking now by way of additional compensation?
My lord,
Additional
4 lakh
documents,
60,000.
nearly 2.5 lakh, their documents are there. And I have produced
You
the
have spent 2.5 lakhs.
2.5 lakhs.
Not having a permit. Therefore, the liability
You have
was,
not preferred any appeal.
liability was fixed against the owner of the vehicle.
The liability was
Now,
fixed.
in what that, my lord, your lordship has kindly observed, insurance company is liable to pay and recover. Only point remanding the matter for consideration of the medical record regarding
Sir,
the
only on
additional
that point,
Please.
nothing else.
With regard to disability, they have not calculated, disability has not been taken into consideration.
Hmm.
And future medical expense also not.
No, then in that case, what we do is, as far as the other heads are concerned, liability and other heads also.
Please.
Other heads we will decide. Only to that extent, with regard to the additional bills, we'll remand the matter. That will be better.
With regard to.
Intended to get compensation under the other head also.
That's what I'm
Disability and
saying.
all.
No. That aspect the court will decide.
Please.
With regard to the pain and suffering and other things, whatever are there,
That your
will
lordship can-
clarify. So they will, for the additional amounts, they will examine the concern. Yes, where is table?
Table, my lord, para 20. In para 20.
It's in Kannada.
It's in Kannada.
I will assist, ma'am. No problem. My lord, the injuries in para 15.
Number 10.
15, para number 15 injury. It is
Where is the
written,
table?
it is para 20, my lord, table.
What is
Para
that
20
mean?
pain and suffering 75,000.
Pain and
lakh.
suffering 70,000,
What are the-
75,000.
What are the injuries?
That's what. Para 15, my lord. Deglone injury arm. Deglone injury forearm.
Forearm.
Deglowing injury to
Burnt injury.
blunt
head.
injury to hand, pain and swelling arm, the fracture of elbow, kandala, injury of skin grafting Western, fracture of elbow, and the deglowing injury to the right hand and the left hand. For that matter, the court has granted, he has examined the doctor,
How many fracture injuries?
only one fracture, Mila. Fracture is only one, but deglowing injuries are two.
Grievous in nature and
Scratch
skin
marks.
grafting has been done.
Tendons are.
Pain and suffering, how much can be granted?
It is, pain
75.
and suffering is concerned at 75,000 is granted. They are not
He was
entitled to get.
hospitalized for nearly 2 months.
No,
That
we
will, that
first clear
will.
on that.
Medical expenses, 2,60,679 is granted. Wow, whatever the medical expenses they have produced. But 29 days he was in the hospital.
29 days.
No. 50 days. 26/4/2017 to at para 17 Mela.
Put here, 50,000 is granted.
For
Mela.
what? For that only, incidental
50,
expenses.
please,
So same we will retain.
please. Further, Malad,
What is that? 75,000?
future,
Normally it includes 50,000
Amenities.
includes 3 or 4 rates Mela, because one is food,
Amenities, Mela.
nourishment, other
No, generally there is only one, transport, nourishment and
amenities,
only that is 50,000 is 1,000 per day, 50,000.
normally he was made to take risk, made to take
Loss of income, that is a different clause.
no, it is
loss
not.
of income has not been assessed.
That we will, loss of income during laid up period. What is the income?
Malad,
He was a student.
he was a engineering student at that point of time. Therefore, Malad, the court has not granted compensation under that.
Not at least the loss of income to the parents to take care of it.
That they have not, that's the reason, Malad, it has to be
Future,
assessed.
even future may.
Yes,
2012 accident.
2017 is accident.
2017.
17.
It is
26.
11,000. So 11,000 into 4, 44,000. Then what about the disability? Loss of future income?
In the judgment, they have not discussed
But
regarding the disability.
What is the evidence of the doctor with regard to disability?
doctor has stated that only 20%. Kindly look at the hands of the.
It is not there.
His entire hand was crushed and he.
No, but it looks, but what is the difficulty in doing is.
That's what the observation of
That's
the
what
court.
it is.
It requires to be.
Or maybe it has deformity or.
Deformity.
This is the difficulty. He can't.
Need to have another surgery.
According to the doctor, it is 20% disability.
Only
to the-
says only 20%.
Or we'll do, as far as the disability component is concerned, disability and future, have you examined the doctor?
We have examined
He
that.
said 20% to the whole body.
No, my lord, it is not discussed in the judgment.
No, it is not.
I don't
discussed
know
So,
from
what we
where
do
he has
is-
taken that 20% disability,
Now, what we do is, for the disability aspect, on disability.
as well as the future medical
Future medical expenses, we'll remind the
Please.
matter.
expenses, the additional document is consent matter.
Loss of income during later period. We will expect.
Along with additional identity.
Let, may I submit, my lord? They have produced one letter regarding the medical, future medical operation. If that is accepted, my lord, the compensation of what we are canvassing may increase. Therefore, what my respect submission, remand by fastening the liability against the insurance company,
No, these components will not change.
it will change. my
How?
lord. Pain and suffering.
Hmm.
If the doctor says
But
that
that's
not in
a
future,
additional amount to be granted. It will be like keeping it too open is not right. No pain and suffering for
That's
whatever.
correct, madam.
You can say
75,000 is
like future operations, anything is required, let it do. Medical expenses, they won't change as it was.
please.
For future, court will add. Then incidental expenses, whatever it is till as of now, that we will calculate.
Please.
Any addition, whatever they adduce the evidence, basing
It
on
may
that,
be.
the police.
Please.
Court agreed with the award passed in MVC number 1394 of 2017, dated 16 November 2019. The claimant is before this court. Okay, the claim petition is filed seeking compensation of an amount of rupees 30 lakhs for the injuries sustained by the claimant in the accident. The court had granted the compensation as per the table given below at page 23 and granted compensation of an amount of rupees 4,60,679. When counsel for the petitioner submits that the court had not granted the loss of income in the later period and also the loss of future earning. In the accident, with the injuries that are sustained by the claimant, it would have a lot of impact on his future life. These aspects were not considered. It is submitted that the what did I say? Before this court, an application is filed under order 41 to 27, whereby he has stated that he has spent lot of amounts after for the future treatment, and he is entitled for the same. Then counsel appearing for the respondent insurance company submits that. For his further contentions, it is submitted that the liability is fixed on the owner on the ground that the vehicle is plying contrary to the terms of the permit and insurance. The vehicle is not having a permit. As such, the owner is liable to pay the compensation. He submits that even if there is no permit, still the insurance company is liable to pay and record the same from the owner as he is a third party to the insurance. Next parallel, counsel appearing for the insurance company submits that the application that is filed under order 41 rule 27 cannot be decided here as it requires evidence. It is submitted that with regard to the disability also, the evidence is not clear on hand and that also cannot be considered by this court. Next para, having heard so and so, there is a material on record. First, coming to the aspect of liability, considering the fact that is a third party to the insurance, still the insurance company is liable to pay and record the same from the owner of the vehicle. Then coming to the heads of pain and suffering and medical expenses and also incidental expenses, court had rightly granted the compensation and there are no grounds to interfere. Considering the fact that this accident had taken place in the year
2017.
Considering the loss of income to the parents, this court is inclined to grant 44,000. In the light of the law laid down in Mekla, 10,000 towards legal expenses. It comes to 4,39,679. Now the other two components that have to be decided is about the future medical expenses and any incidental expenses that are incurred after for the future treatment and the pain and suffering, looking at the further pain or any amount under the pain and suffering. As rightly argued with the accounts for the insurance company, this court cannot, it requires evidence and examination of witnesses. This court is not inclined to go into those aspects, and the court deems it appropriate to remand the matter for the specific purpose of deciding the future medical expenses and any expenses incidental thereto, and also the liability aspect by examining the doctor. Accordingly, the award impugned dated so and so is set aside for the limited purpose of examining for future medical expenses and also for considering the liability and any other incidental expenses in the process of future medical expenses. Basing on the additional documents. Yes. Without further notice, the party shall appear before the court on 13th of October, and within 4 months from the date of receipt of the copy of the order, the court shall decide the same. Yes, next. I already said it should go to the court and it should be in a fixed deposit. Yes, next.
Madam, my calculation is ready, ma'am. Calculation I have made.
Yes, take that. Have you seen that?
Yes, madam.
Afternoon, you come up with yes. Look at that memo. Yes, next.
Number 14. Pradeep B for appellant.
Yes.
KV Naik.
Take this in that file. Yes. You're on what ground?
That on the date of accident, there was no DL to drive the insured vehicle.
What is the finding of the court?
The finding of the court, my lord,
who is R4?
Notice is dispensed.
No.
there are two vehicles in
your case, who is R4? In your case, who is R4?
Expert. They place expert.
Notice
Insured of the Tata Sumo. Insured of the Tata Sumo.
Owner of the vehicle is before the court. Vehicle which you have insured.
That is the third respondent.
He served. Yes.
He has served in the notice.
What is the finding on that liability aspect by the court?
The one lorry, it's.
Come to paragraph 18.
Please. That in this, the two vehicles are involved in the accident. Both were insured with the same insurance company. Regarding negligence 50-50, it is held. There is no dispute in that aspect is concerned.
You want pay and recover. For pay and recover, what is the evidence?
Please.
Whether the charge sheet is filed under the motorway, then?
Para 14 of the judgment.
Yes.
Driver of the lorry, and the charge sheet was filed against the driver of the alleged lorry. Tata Sumo and same was not challenged so and so. Even though respondent taken the contention drivers of the vehicle are not having the so and so date of accident, they have not chosen to examine the RTO or the produce the any document.
That's sufficient.
The charge sheet also does not so and so.
Yes.
We have examined the IO of the investigating officer. He has given.
He cannot tell anything contrary to the charge sheet that is filed.
No, that's what. He has not collected the collected driving license of the accused. This is the only context.
RTO you would have examined.
But driving, unless driving license number is provided to us, it is very difficult for us to secure the driving license.
That's not the ground.
That is the only ground.
Yes. What about your enhancement?
No enhancement is in all grounds.
It is granted. Not required. Agreed with the award passed in MBC number 1850 of 2015, dated 5th November 2019. The insurance company has preferred MFA number 294 of 2021 and the claimants have preferred MFA number 1320 of 2021. The tribunal has granted the compensation as per the table given below at page number.
Pardon me.
At para number 17. When counsel appearing for the insurance company submits that the driver of the offending vehicle is not, driver of the lorry
Please.
is not having a valid driving license, in that case, a principle of pay and recovery will apply. But the court has played to apply the same and granted the compensation. It is submitted that as far the appeal of the insurance company, the claimant is concerned, already the court has granted compensation on all the heads on the higher side. And it requires no enhancement. Next parallel, and counsel appearing for the respondent, not respondent, but the claimant submits that the court had failed to grant the just and reasonable compensation and requires to be enhanced on all the counts. Next para. Having heard the counsels on either side, there is a material on record. The charge sheet is not filed under section. The court has not filed under section 3(1), read with section 181 of the Motor Vehicles Act. There is no evidence on record that there is no valid driving license. They have examined the investigating officer. By examining the investigating officer who has filed the charge sheet, he cannot give evidence contrary to the charge sheet which is filed by him. In those circumstances, the evidence of the investigating officer will not inure to the benefit of the insurance company. Hence, in the considered opinion of the court, the tribunal had rightly held that the insurance company is liable to pay, and the supposed do not find any reasons to apply the principle of pay and recover. Then coming to the compensation, this court has perused the injuries that are sustained and the compensation that is awarded. On all the counts, reasonable compensation is awarded and it calls for no interference. Accordingly, appeal of the claimant and appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred. Yes, next.
4 days delay.
What is that?
4 days delay in
IA number 1 of 21. Condone the delay of 4 days. Condone. Yes, next.
Tail number 15.
I am appealing for the appellant, my lord. Claimant appeal, my lord. Enhancement, my lord. Claimant appeal for enhancement.
You are ready?
A.N. Krishnaswamy.
Contributory negligence taken 25%, my lord. In discussion, para 9 of the trial court.
It's a case of death or injury.
Injury, my lord.
Please come to that particular observation, discussion.
Injuries in discussion. Para 9 of the trial court judgment, my lord.
Come to that.
P3 and P4 sketch.
Yes, read.
The exhibit P3 is the spot measure wherein it is mentioned that the road is 35 feet width and it has 3 feet wide cement.
Where are you reading?
Para 9 of the trial court judgment, my lord.
It starts from where?
No, middle of the.
So you have to tell the court that it is the middle of the para. Otherwise, how can I find it?
Yes, sorry.
Yes. Exhibit P3 is a spot Mahajan.
Yes, madam.
Please read.
Exhibit P3 is the spot merger wherein it is mentioned that the road is 35 feet in width and it has 3 feet wide cement footpath on the either side, and the accident has occurred is distance of 15 feet from the left side edge of the road and 20 feet away from the right side edge of the road. Considering the direction in which the bike was moving, thus the car has gone to the wrong side of the road for about 2.5 feet, and the exhibit P4 discloses that the topographical the spot of the accident, the road was straight at the place. Exhibit P5 IME report discloses that the bike.
There is a finding that the car is going on the wrong side. Just because it is a head-on collision, the court cannot give such a finding. So even the other car is coming on the wrong way and straight away going and hitting him, then also he has to be careful. That's not the finding. That can't be a finding on that. I've seen. When the court gives a clear finding, the vehicle, that is the car, is going on the wrong side. And though even the car is coming, anticipating that he would come on the wrong side, he has to be careful. No. Yes. What about the compensation?
Compensation awarded my lord 7,67,500.
Come to that. Come to the table. Yes, what are the injuries?
Injuries, my lord.
How many fractures?
Ink page in 17, my lord. Second line, my lord. Para 19. The petitioner himself has given evidence PW and also examined.
Fracture of right fracture acetabulum, right fracture femur shaft, right fracture calcaneum. So there are 4.
Amputation of little toe, my lord.
Yes. There are 4 fractures and amputation of the toe. Court had granted 50,000. What do you say? Where do you get the amputation of the toe?
Illide nodi sir. 21 para BL ide.
Para?
Amputation of little toe.
Paragraph?
Para 29 BL ide. First line, my lord. Pain and suffering. B. Pain and suffering.
Yes, with pain and suffering, it speaks about amputation of the toe. But when it comes to the
evidence is there, my lord. Doctor evidence is there. Doctor evidence. Doctor evidence is there, my lord.
Read.
In Kannada, my lord.
As far as the right toe is concerned, show it to him.
Sorry, sir. Doctor.
Give it to him.
ಇಂಪ್ಲಾಂಟ್ ಅಳವಡಿಸಲಾಗಿತ್ತು. ಇಮ್ಮಡಿ ಮೂಳೆಗೆ ಸ್ಕ್ರೂ ಅಳವಡಿಸಲಾಗಿತ್ತು.
So, under the head of pain and suffering, another 40,000. Let's go to the table. Medical expenses as it is. $2,46,160. 3. Future medical expenses nil.
nil, my lord.
Incidental expenses, how many days he was in hospital?
32 days, my lord.
32.
Yes, my lord.
32,000. Then loss of income during
Laid up.
laid up period. Which year is the accident?
2017, my lord. Income taken only 8,000, my lord.
17. 11,000.
And future prospect, 24% disability, my lord.
First let us complete this. 44,000. Then what is the disability according to the doctor?
Particular limb, 73%, my lord. Tribunal taken 24.33.
Correct.
Yes, my lord.
24.33,
my lord.
33. So same, we'll take with 11,000. It's 24%. What do you say about future prospects? So 11,000. What is the age?
25 years.
So 40%.
Yes, ma'am.
Comes to 4,400. That is 15,400 into 12 into 18 or
18.
18 into 24.33 by 100. It's coming to 8,09,313. Then
amenities.
Amenities. How much is granted?
5,000, my lord.
Huh?
Yes.
Yes. For 24% disability and amputation of the toe, 50,000. It's coming to 12,81,476 against 7,67,510. Please come. Agreed with the award passed in MVC number 1272 of 2017 dated to 3rd February 2025. The claimant is before this court seeking enhancement of the compensation and also questioning the 25% contributory negligence that is fixed by the tribunal. The claim petition is filed seeking compensation of an amount of ₹33 lakhs for injuries sustained by the claimant. It is a case of the claimant that on 29/9/2017, while he was riding the motorcycle from Nanjangud towards his village at Nanjangud, Gundlupet main road, and about 7:30 p.m. when he reached near Kalale gate near Siddhavirappa's land, a car driven by its driver came in a high speed and in a negligent manner from opposite side and dashed against the motorcycle of the petitioner and he sustained injuries. The tribunal has fixed the contributory negligence on the claimant and it is observed that as per Exhibit P3, the South Mahajar, the road is 35 width road and it has 3 feet wide cement footpath on either side. Considering the direction in which the car was moving, the court has felt that there is about 20 feet away from the right side edge of the road. The court also gives a finding that the car has gone to the wrong side of the road for about 2.5 feet. But however, as there is enough space, as it is a head-on collision, had the claimant been cautious, the accident could have been avoided and fixed a contributory negligence at 25%. Land Council submits that when it comes to the compensation and considering the amputation of the right toe, the court under the head of pain and suffering had not granted a reasonable amount. This accident had taken place in the year 2017, but the court had considered how much?
8,000.
8,000 as income, and considering the 24% disability, the amount of compensation that it is awarded and the head of loss of immunities is not a just and reasonable compensation, and on all counts compensation needs to be enhanced. Next parallel, and counsel appearing for the respondent insurance company submits that the court, basing on the sketch and the evidence on record, has clearly held that there is contributory negligence on the part of the claimant, and even on the quantum also, on all counts, the amount that is awarded is just and reasonable. Next part, having heard so and so. First, coming to the aspect of contributory negligence, this court has perused the findings, observations of the tribunal. The court gives a finding that the driver of the car is going on a wrong direction. According to the court, as still there is a space, the claimant would have been careful and the accident could have been avoided. As such, there is a contributory negligence. That finding of the tribunal, this court is not able to appreciate. When there is a finding with regard to the vehicle being on a wrong direction, the court ought not to have fixed a contributory negligence on the claimant. Then coming to the compensation, considering the 4 injuries and the amputation of the little toe, under the head of pain and suffering, this court is granting 90,000. Medical expenses, court had rightly granted. No interference is called for. Towards incidental expenses, this court is granting an amount of 32,000, considering the 32 days of hospitalization. Then coming to the loss of income during the later period, considering that this accident had taken place in the year 2017, 11 into 4, 44,000. Then coming to the loss of future income, court has already considered 24.33 as the disability to the body. Hence 15,000, but he is entitled for future prospects, considering the 24% of the disability. So 11,000, 40% is 4,400. His income is 15,400 into 12 into 18 into 24.33 by 100 is 8,09,313. Considering the disability of 24.33%, under the head of loss of immunity, this court is granting 50,000. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,81,476, which the insurance company is, there is no dispute on that. On your, which the insurance company is liable to pay, and the enhanced amount carries 6% interest. So it is partly allowed by enhancing the compensation from 7,67,510 to 12,81,476. The entire amount shall, no, then in that case, it's enhanced amount 6%. That's the entire amount, because it's already as the liability is fixed on the negligence is fixed on the driver of the opposite vehicle, the entire amount the insurance company shall pay. Yes, next.
Cell number 16, KT Gurdev Prasad for appellant, D Manjunath.
I'm representing the First Respond Insurance Company, my lord.
These two appeals are arising out of the same accident, but the judgments are not common, separate judgments. In the first is MFA 68 of 22.
BC number 7014.
Yes, 7014, arising out of MFA 68 of 22.
Of?
68 of 22. MFA.
2014.
Yes, 22.
19.
That is 7014 of 19.
No, first is 7014.
Oh, yes.
MFS 350 arising out of?
Arising out of 7013.
7013. Separate orders.
Separate orders.
So now we are looking at the first one.
Yes.
Case of death or injury.
The first one is case of injuries.
Please come to the table.
Para 15 of the judgment. He was a pillion rider, and the opposite motorcycle came and dashed against him. My grievance is that since he is a pillion rider, the contributory negligence will not apply. The court has determined 85% on the offending vehicle and 15% on the rider of the motorcycle. In this case, the petitioner is a pillion rider.
Offending vehicle is insured and the vehicle on which you are a pillion rider is also insured.
Yes.
Yes, what do you say on that?
My lord, so far as the injured in this case is concerned, it is a matter of composite negligence. There are two vehicles involved.
Composite negligence is on the rider, but not on the pillion rider.
Yes.
So as far as pillion rider is concerned,
So far as the
insurance
pillion
company-
rider is concerned, my lord, so far as the injuries and the nature of accident is concerned, it was a head-on collision between the two vehicles and the class of vehicle is similar. My lord, it is also the findings of the tribunal that it was straight road, and looking into the Mahazar and the spot sketch, the tribunal has determined the negligence to an extent of 15% on the rider. But the rider is not a party, but the rider has not been made as a party in the claim petition.
Yes.
Even otherwise,
Whereas, my lord, the rider's claim petition, the riders, the LRs, they filed the claim petition, that is the another MFA, that is 16.1. The rider died in the accident. Therefore, the LRs claimed the compensation, wherein the honorable tribunal held the 15% negligence on the part of the rider.
Then that we will consider. As far as this first one is concerned, it is for him because it's a case of composite negligence, either to go against them or against the other one. No, he has chosen to go against you and not made the other person as a party. No, we will leave it if there is a finding.
When they have not made, my lord, the attribution of negligence or the determination of the degree of negligence is a secondary aspect. If they could have made the rider as a party here, or the LRs of the rider as a party, and that's an insurance company, he would have an opportunity so that the determination of the negligence would be a different scenario altogether. Here he is not a party.
Cannot compel him to make who should be the parties, and the law permits him to proceed against anyone. So as far as the first case is concerned, the liability
proceeding, anyone would arise if they are the parties to the proceedings, my lord.
Yes, I will. I understood your argument. I'll give a finding on that. So contributory negligence fixing on the pillion rider would not arise.
Yes.
And as the court has held that it is 20%, 80%. Now he has chosen to file the case against you. So 80, you will be paying the entire compensation, and 20% of the compensation you can realize from the owner of from the rider of the vehicle.
Yes. Deducting 15% is not correct. And now so far as injury
it is 15 and 85.
85.
15.
Then coming to the compensation.
Internal page 15.
Internal page 15.
15. He suffered right frontal bone fracture.
So where is the table? Table. Come to the table.
Table.
At internal page number 19.
Yes.
19. Pain and suffering, of course, I have no grievance.
Yes, so 80,000 as it is.
Yes, medical expense also same. Nourishment, food and conveyance.
1 minute. Let me write down that. 1,52,760. Then how many days he was in hospital?
11 days. 11 days.
So another 1,000.
Yes. Loss of income during later period. The tribunal has not determined the income at all. He was doing fruit business.
Loss of income during later period. Where is the evidence that is written before the court?
No evidence.
So which year is the accident?
Yes. 14,000.
Yes. 14 into 4. It comes to 56,000.
So far as disability is concerned, I have not examined the doctor.
Future medical expenses?
Future medical expenses 20,000, of course.
As it is?
Yes. Amenities.
Loss of amenities because you have not examined the doctor.
Yes.
No evidence. So it has to be as it is.
Yes.
It comes to there is no enhancement except for this 1,000 and this loss of income during the later period.
Yes.
He was only inpatient for a period of 11 days, my lord.
Only 11,000 we have granted.
Your Lordship calculated some 11 into 4 or something. 40.
No, no, that is with regard to the loss of income during the later period. So now it is at 2,97,760 to 3,49,760. Please come.
That entire amount he has to pay.
Agreed with award passed in MVC number 7014 of 2019 dated 17th April 2021, whereby the court had granted 2,97,760 and held that there is contributory negligence on the part of the claimant, which is apportioned at 15%. The claimant is before this court. Then counsel appearing for the claimant submits that the claimant is a pillion rider and the accident, the court has fixed the liability on the owner of the vehicle at 15% and on the insurance company at 85%. He submits that it's a case of composite negligence. In those circumstances, he can pursue the same. He can recover the compensation either from either of the tortfeasors. As such, he has filed the petition against the rider of the
Offending motorcycle.
rider of the offending vehicle. In those circumstances, question of contributory negligence, fixing the contributory negligence on the pillion rider will not arise. It is submitted that coming to the compensation, the court under the head of loss of income during the later period has not awarded reasonable compensation and he was in hospital for 11 days. Next para. Learned counsel appearing for the respondent insurance company submits that he has not made the owner of the vehicle, the rider of the vehicle as a party to the claim petition. Had he been made a party to the claim petition, there would have been a remedy for the insurance company to recover the money from the claimant. It is submitted that then in his absence, how is it decided that 80%?
He has to file a separate he has to file separate proceeding and he has to-
the court. What did you say? Claimant. Unfortunately, in this case, the rider is not made a party. It is submitted that the court had rightly fixed the contributory negligence, and even the compensation that is awarded is also just and reasonable, and no interference is called for. Next part. Having heard the counsels on either side, so and so. There is no dispute about the fact that it's a case of composite negligence. In cases of composite negligence, it is for the claimant to proceed against any one of the tortfeasors. In this case, he has proceeded to, he has taken a decision to proceed against the opposite vehicle. In that case, and as rightly argued by the learned counsel for the claimant, that is for the claimant to decide, and he cannot be compelled to pursue against the both. When once the claimant had not made the driver as a party to the proceedings, this court is not able to rider of the vehicle as a party to the proceedings. This court is not able to understand how the court has fixed the liability on a party who is not a party to the proceedings. Even if such a liability is fixed and has fixed and that is now given that is now attributed to the claimant who is a pillion rider at 15% and 85%. This observation of the court is contrary to law, and such a finding ought not to have been given by the court. The insurance company has not preferred any appeal against the order passed by the appellate, passed by the tribunal. in these circumstances, this court is of the view that the contributory negligence cannot be fixed on the pillion rider, and the insurance company is liable to pay the entire compensation. Next, coming to the compensation, the tribunal has awarded the compensation as per the table given below. Extract the table at paragraph number 23. Under the head of pain and suffering medical expenses, future medical expenses, loss of amenities, court had rightly granted the compensation. No interference is called for. Coming to the incidental expenses, considering the 11 days of hospitalization, this court is granting 11,000. Coming to the loss of income during the later period, considering the fact that this accident had taken place in the year 2019, 14 into 4, this court is granting 56,000. In the light of the law laid down in make laws so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,49,760. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 2,97,760, 3,49,760, and the entire amount has to be paid by the insurance company. Yes, next.
Next matter is the case of death. Parents are the claimants. He
is the rider of the vehicle.
He is the rider of the vehicle. In view of this finding.
The earlier case, it could have made the rider oblique LRs of the rider. Yes. Then in this case, then 15% has to be.
It has to be confirmed.
And let us see the compensation.
Yes,
What
ma'am.
is the age?
Age is 24 years.
Occupation?
Occupation is the computer operator.
Any evidence in that regard?
There is no evidence.
So which actually we have to take 14,000.
Exhibit P13 is the decree certificate. He completed B. He
Completed B.
Completed
Then
B.
income to be taken at how much, Mr. Counsel?
My lord, may I make one submission, my lord?
Yes.
My lord, they have stated in the claim petition that he completed engineering and document is marked as exhibit P13. But there are no other documents except this stray document. Another aspect is, my lord, they have stated he was also pursuing MTech, and he was also working as some computer operator and earning some 25,000 rupees. Submission. No documents produced. No documents produced, my lord. The tribunal has rightly taken 12,000 rupees as an income.
No. He has not produced any document in support that he is doing MTech. We're not going to that.
Yes,
Admittedly, he is an engineering graduate. So, what is the consistent view of the Honorable Apex Court in this regard? I think some 18,000 is taken in several matters.
25,000 rupees.
In which case?
In
Ashwin
Jayantilal Modi.
Which year is that?
That is 2015 two Supreme Court judgment. And another judgment of this Honorable Court, Divisional Bench of this Honorable Court, has also granted 25,000 rupees.
Which year is this accident?
This is 19.
Yes.
My lord, in this regard, my submission is this, my lord. The citation of the Apex Court referred by the Appellant's Counsel, this is in Ashwin Bhai case of 2014, my lord. The factual matrix is altogether different. In that case, he completed the mechanical engineering from a very prestigious institution, and there was sufficient pleadings and the document evidence in that case. My lord, may I make one submission? My lord, may I make one submission, my lord? He was given an offer letter. There was a campus placement. He was given an offer letter from the Reliance and the Tata Consultancy. So therefore, taking into consideration of all those aspects, my lord, 25,000 rupees was considered as an income per month of an engineering graduate in that case. The factual matters of that case is altogether different from that of
We will
this.
take 17,000. We will take 17,000.
17,000 is very less.
My lord, my request is, my lord, may kindly take 15,000 instead of 12,000, my lord.
We will take
I got the
17,000.
citation also, the judgment of this Honorable Court.
Because every citation has its own, we can distinguish it on facts. Yes.
Para 10 of the judgment.
So citation is sir. So Gurudev Prasad, sir, citation please.
It is MFA number 104894 of 2019. Dated 28th February 2020.
And Supreme Court judgment in para 11.
But there are judgments in Supreme Court which has taken less also. Less
Yes.
than 2025.
The recent judgments.
Recent is like, that is, we have to look at 2000, relevant point of this accident is 2019. In
Yes.
those years, what is the amount taken by the Supreme Court? Definitely there are here and there.
Not
Judgments.
17, some 17,000 is very less.
70?
Your lordship
Actually,
is
differs, my lord.
Yes.
17.
take 70.
Academic performance, nothing has been placed before this court.
22,000 rupees maybe.
22,000 will not take.
No, it's
In fact, these judgments are very old.
But
2013
what
accident.
to do like this, that is not the constant view. We cannot take like basing on one judgment, and there should be a basis we can understand on what basis they have taken.
That's why my lord, I made a submission. The factual matters are altogether different. What is the education? What is the academic performance? What about the materials that the claimants have
So
placed
what
before
it
the
says
court?
is, the accident took place much earlier to 2011. Therefore, the amount taken at the rate of 20,000 during that period might have been adequate as per the course. Even considering the year 2012, according to the government, the amount of rupees 22,000 was paid as salary to the. No, if that we have to see, not necessarily, no, like with his performance, with his, where is the guarantee that he'll get a job in a government this thing?
But this is an accident during the year 2019. Much later.
Place any judgment where in a relevant point of time the court has granted will consider.
Not 17, some amount has to be increased.
Some amount is what?
Lord, my lord, in Arvind Kumar Mishra's case, it was actually in fact referred in
He was
Aminab Bhai's
completing
case.
B, proceeding M.Tech.
For that there is no material on record.
No, there is no material.
Deposition.
Not deposition, any
There is no-
evidence. If you are pursuing, you should be getting, you must have had your admission
20,000
card.
rupees, 20,000 rupees maybe take.
My lord, but
Yes.
nothing is there, my lord. Whether he got any placement in the campus, how
Don't
about
go to
his,
the placement.
no,
Don't
my lord,
go
how
to the
about his, my lord, how about his the academic performance? All these things are yardstick to determine the salary.
No, that's why I'm asking you, what is the view of the court is, without going into the, let's not compare this case to the some other case, but where a person is a BE graduate, what is the law on that? Supreme Court, like in each and every case, has not considered their competence and all. Even for a BCom graduate, also court had taken 15,000 in a recent judgment.
Yes.
So he is a BE graduate. What would be the appropriate amount? Definitely not 25,000. Will not take 25,000. But
My
there
lord,
should be
my
some.
lord, my lord, if I am not wrong, my lord, I don't know what is this BE that he obtained, in which specialization, number one. The second one, my lord, what is his academic performance? Nobody knows, my lord. Even the engineers, my lord, engineers at this point of time, they are getting 50,000 rupees, my lord. The package, my lord, may put it across to this, my lord. But it's a very the pragmatic view, this, my lord. Even in MNCs, now the engineers are getting 3 lakh rupee, not more than 3 lakh rupees.
We'll have tomorrow. Please come with, because I do not want to take some amount and it is not create any kind of confusion.
20,000, I agree for 20,000.
And 20,000 for that also, any law, anything on that, please get it. Otherwise, I'll also.
These are the reported judgments, that's all.
Because 2011 accident and considering 25,000 is definitely on the higher side.
Certainly.
So that's why we have to, there should be a balance so that whatever we take should be adopted for further also in other cases. Now I say like, okay, like if
Minimum wages for the technical graduates, my lord.
Tomorrow, this is smarter tomorrow. Yes, next.
Cell number 17, Girish B. Baldare.
Yes. Let's see. He was here only. Pass over. He'll come. Yes, 19, 18.
Cell number 18. Cell number 18. Ravish Benny,
Insurer upon negligence, please.
On negligence.
Please.
Court had fixed a contributory negligence.
Not
According to you, it has to be fixed now.
against us. The charge sheet filed against the claimant against the negligence only, please.
Charge sheet is filed against the claimant.
Against our driver and also
The claimant.
rider of the vehicle, appellant, claimant.
Take that.
Well, a table at
No, not the table. We will go to the aspect of negligence.
negligence. Para 35, please. Entire liability fixed against us.
Read it. First, we have to see the finding on the negligence, that is at issue number
No,
1.
not given, please, ma'am. That the
But that whatever is the discussion, we'll see.
Para number 17, madam. 17 and 19 is very relevant. No? This case, what happened, the cleaner of the offending vehicle himself is a complaint before the police. He himself stated that the
Claimant is riding.
claimant is, in this case, what happened, lorry offending vehicle was parked in the middle of the road. It is a 30 feet road.
If the claimant is riding, which vehicle?
Moped, two-wheeler.
Going on a moped.
Yes, ma'am.
The other vehicle is a lorry.
Other vehicle is lorry, which is parked in the middle of the road. It is 30 feet road. Therefore, the complaint himself is a cleaner of the offending vehicle. Therefore, he has stated in the para number 19 for a moment.
Is it true that the charge sheet is filed both against?
Yes, in this case, what happened, madam? Charge sheet filed against the driver of the vehicle and the petitioner. The driver of the vehicle pleaded guilty and paid a fine. Then trial continued to the against the petitioner. Now the trial is ended on 17/8/2023 by acquitted.
On the ground?
On the ground of point of evidence.
Lack of evidence.
Yes, ma'am. It is at the time of passing the award, the trial was going on. No? Now, by order letter 17/8/2023.
So, as on the day, giving not fixing the contributory negligence on you is bad. Is bad. Charge sheet is filed against you. You have not questioned the charge sheet.
I contested the matter before.
That's what.
Yes,
what
ma'am.
as on the day.
Yes.
Why did the court not fix the contributory negligence?
In this case, what happened?
Acquittal on a criminal case is basing on the touchstone of beyond reasonable doubt.
Yes, ma'am.
Prima facie, looking at it on preponderance of probability.
Yes, ma'am.
There is whether there is negligence on the part of the rider of the moped or not. Now, under these circumstances, we have to look at the evidence on record.
Yes, ma'am.
We'll look at it. Let's read. Let's read from issue number 1.
The relevant is para number 17, madam. A perusal of the spot margin report page exhibit P and the rough sketch prepared by the jurisdiction police market exhibit P5. This was that the said road where the accident took place is a narrow road having only 30 feet width.
What is the time of the accident?
Morning 4:30
4:30?
4:30 a.m. A lorry was parked on the road and the only left side wheels of the said lorry were rested on the mud road, and the said lorry was parked in such way to that on the same causing the obstruction of the ongoing two-wheeler vehicle. Though the FIR charge sheet disclosed to the petitioner has also been added as accused number 2, the fact that the respondent number 2 has submitted the guilt of the JMFC in court and
According to him, he could not see the parked vehicle.
He see the vehicle 15 to 20 feet from the parked lorry. Lorry was parked not on the main road, it was parked on service road. Service road left side park.
No service road, it is only 30 feet road, as admitted by the cleaner himself.
Kindly peruse the sketch, please, ma'am, then you will not decide. I don't.
Please,
We'll do it in the afternoon.
By 2:30.
We'll see. This matter will be continued.
Obviously.
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ ಇದು ನಾನು ಮೋಸ್ಟ್ಲಿ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ನಿಮ್ದು ಇಲ್ಲೇ ಇದ್ದೀರಲ್ಲ ಅದಕ್ಕೆ ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ 2:30 ಬನ್ನಿ ಸರ್. ಸರಿ ಎಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Yes, continuation matter.
It was responded.
Yes. Yes. You're saying you're on negligence.
Please,
Court has not fixed the
not
contributory
fixed.
negligence.
One more submission, there is a 50 to 25% future cost considered by the energy is not correct.
First we will go to this.
Please,
First we'll go to this aspect. Where is it?
please. Para 20, para 35, please.
This
Very-
accident had taken place at morning 4:30.
5 p.m.
5 a.m.
5 a.m.
Hmm.
Now, kindly take the sketch, please. Ma'am. Exhibit P5.
Yes. Yes.
Lorry main road, not service road, only left side. Not on highway, please.
He's also going on the service road.
Service road.
Then
If the main road is parked, I can understand, please. It is parked in the service road, that to left side,
parking you
mud
have to
road
see-
of the service
No,
road.
you have to, people do use the service road, not alone you. So you have to put the parking lights on. How does it matter? He's
driver-
also going in the same road.
Our driver is
You are-
not put the
No,
blinking
you are-
light, all those things.
Yes, that caused the accident.
50% at least fixed against the
Yes, next. On the quantum,
quantum, please, 75, income taken by the, to be taken
appeal is
9,500.
there.
Yes, my appeal is there for enhancement, but only in the heads up income of the claimant, my lord. Rupees,
1 minute. You are not on pain and suffering, 75,000 is okay. Then,
For one fracture is higher side, 40% may be considered, please. Only one fracture of the
no,
right
no,
knee.
not one fracture, man. He suffered more than four.
40,000, we are giving pain and suffering basing on the number of.
Per day, for monthly income of the decision.
So come to the table at
Please.
paragraph 34
Yes,
and looking at those heads one
Yes,
after
yes.
the other and permitting the court to write down and then please submit.
please.
Medical expenses 91,000.
Actuals, please.
Next, loss of earning during laid up period.
Then future medical expenses also.
52,500 is given,
Huh?
please.
Which year is the accident?
2016, man.
16, please.
2016.
For 3 months, please.
Where?
Kindly consider for 3 months for the later period.
9,500.
Yes, ma'am.
How many days he was in hospital?
150 days, man.
50 days. you
150 days, 150 days, man.
150.
Please.
So 150 means how many months? Almost 5 months.
5 months.
So we'll
As
grant
inpatient, man.
we will grant after that another 2 months.
Please.
So 9,500 into 7. Loss of income. Into 7 comes to 66,500. Then incidental.
25,000 awarded, correct, rightly.
Well, how it is right, 150 days hospitalization, how is it like 1,50,000 we will award?
No, no. For transportation attendance, 25,000 awarded by the tribunal.
That's what I'm saying. He was in hospital for 150 days.
That to
So it's into 1,50,000 into 1,000 a day. That's how we are calculating. Yes, next.
Then, madam, future
Next,
medical expenses.
Transportation is over, food nourishment is over, amenities. What is this expectation of life amenities? Not two heads. What is the disability according to the doctor?
37% whole limb disability. That is considered the 12% to the whole body is correct.
33.5 is the right knee, the 4% of the left knee in the both.
37% and 12% is rightly taken. So now loss of future income. 9,500 into 12 into what is the multiplier?
15 multiplier.
15
yes.
Into
40 years.
12 by 100.
2,05,200.
2,05,200. Then for this,
Future,
under the head of
future
loss-
prospect 25% to be added. Future prospectus added in.
How can it be? For a disability of 12%, why would we
Both
grant
legs, he is a bar bending worker, he can't do.
loss of future income? No, loss of future income is 2,05,000. Then now amenities. Disability is 12%. Under both the heads put together, another 10,000, 30,000. Legal expenses 5,000, 10,000. It comes to 5,93,300. What is granted?
5,30,000.
530, 350.
530. Please come.
Contributory negligence.
Agreed with award passed in MVC number 68 of 2018, dated 30th October 2021, whereby to 2021, both the insurance company as well as the claimant are before this court. Insurance company's appeal is MFA 822 of 2022, and the claimant's appeal is MFA 3057 of 2022. Insurance company is mainly on the ground that there is a contributory negligence on the part of the claimant. That aspect was not considered by the court. Further, for a disability of 12%, court had considered the future prospects for which he is not entitled. The compensation that is awarded is on the higher side, and there ought to be been a contributory negligence on the part of the claimant. Land counsel appearing for the claimants of this act, the court had rightly placed because of the negligence on the part of the driver of the vehicle who has not switched on the parking lights at 5 a.m. Next, it is submitted that the compensation that is awarded by the tribunal is not just and reasonable, and the same needs to be enhanced. Next paragraph. Having heard the counsels on either side, produce a material non record. First, coming to the aspect of contributory negligence. On 12/1/2016, the claimant was traveling at about 5 a.m. when he was moving near PESIT College opposite to Police Layout, Shimoga City. The driver of the lorry parked the lorry on the road without flashing the parking light or giving any caution signal, the claimant has dashed the same and sustained the injuries. This court has perused the order of the tribunal. Tribunal has observed that the driver of the lorry has pleaded guilty. And the fact that at 4 a.m. as there was no parking lights on, it is the negligence of the driver of the said vehicle. Land counsel appearing for the vehicle. The submission of the land counsel to the insurance company that the vehicle is parked on the service road, but not on the main road. Hence, there is contributory negligence on the part of the claimant. This court is not able to appreciate the said contention. Both the vehicles or the vehicle is parked, lorry is parked on the service road, and the claimant was also traveling on the service road. At 5 o'clock, at 5 a.m., if the vehicle is parked without parking lights, there is no possibility for the claimant to see the same unless he reaches the place. And in those circumstances, this court is not inclined to fasten the contributory negligence that apart.
One
Even in
submission, the petitioner saw the vehicle from 20 feet from the lorry.
But it is difficult to stop. The court has also acquitted the claimant in these facts and circumstances. This court do not find any reason to fix a contributory negligence. Coming to the compensation, considering one fracture injury, this court is inclined to grant 40,000. Medical expenses, court had rightly granted, no interference is called for. Loss of earning during the later period, considering 150 days of hospitalization, this court is taking 7 months, that is 9,500 into 7, 66,500. Towards the incidental expenses, considering the hospitalization of 150 days, this court is granting 1,50,000. Coming to the loss of future income, court had already assessed a disability at 12%. This court finds no reasons to interfere. 9,500 into 12 into 15 into 12 by 100 is 2,05,200. Towards loss of amenities, consider the disability of 20%, 12%. This court is granting 30,000. In the light of the law laid down in make losses or legal expenses, 10,000. Altogether, the claimant was entitled for an amount of rupees 5,93,300. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 5,30,340 to 5,93,300, and the appeal of the insurance company is dismissed.
On submission,
Amount in
charge
deposit
sheet against the negligence point only, please. Against the petitioner, there is a negligence aspect only. Charge sheet against him, negligence aspect, not very any other this thing here.
Yes.
Kindly consider to 50% at least.
Yes.
And 6% interest from the date of the petition.
Appeal of the insurance company, contentions record, and the amount is the interest of the rate of interest is reduced from 9% to 6%. Yes.
And transfer the
partly allowed.
and transfer the amount before this.
That is already said. Yes.
Appeal for appellant, my lord. The case of injury, Paraplegia case, my lord. The liability fixed to the owner of the vehicle on the ground that the liability on the policy.
Then,
my lord, the enhancement is there, my lord.
you want enhancement, we will do.
Yes, ma'am.
First aspect is about their liability.
Yes, ma'am.
They are not
But
liable.
the third part.
The owner is served.
Owner is served, my lord, but he is
Let's
not
see.
appeared.
Let's see the order and what is the condition.
My lord, the doctor says that, my lord, 100% disability for his work, my lord, but trial court consider only 75%. The functional disability is 100% is considered, and future prospects may be.
The Kajal's case give the judgment. What is the age?
My lord, 38 years. Lady is working as a tailor.
What is his income according to him?
My lord, my income, my lord, 12,000 per month, my lord. The trial court considered
12,000?
12,000. The trial court considered 8,500.
Which year is the accident?
2014, my lord.
14 is 8,500.
Yes.
Please come to the finding with regard to this 100% disability.
Lord, para number.
Due to non-functioning of both lower limbs.
Yes, my lord.
She confined to the wheelchair.
Page number 21 of the judgment, my lord.
Give the judgment.
The para is commenced in the page number
So
20.
first of all, we'll take the medical expenses. Medical, first we'll start with medical expenses.
Yes,
As it is. Huh?
yes, my lord.
50,492. Pain and suffering.
The 3 lakhs rupees is awarded by the trial court.
How much is awarded?
3 lakhs, my lord.
Same we will award.
Attendance and conveyance charges 3.
That we will go.
Yes.
That will go. Which year is this accident?
2014, my lord.
How many days you was in hospital?
My lord, 16 days hospital.
Take a printout of this and keep it. Take a printout of this and keep it instead of every time getting this file. So loss of future earning, considering the accident is
2014.
So 8,500. Comes to 3,400. What is the multiplier?
Multiplier is 15, my lord.
Any amount is granted for future medical treatment?
Future loss of income, my lord.
Future medical treatment.
Future medical expenses, 1 lakh rupees is awarded.
Where do you get it? 1 lakh. What is the evidence of doctor?
The doctor says that is required more amount for it. There is no specific amount was not stated, my lord.
It's coming to 48 lakhs. Yes, please come. Agreed with the award passed in MEC number 739 of 2017, date 30th August 2023. The claimant is before this court seeking enhancement of the compensation as well, questioning the liability fixed on the insurance company. Next, the claim petition is filed seeking compensation of an amount of rupees 40,35,000 on account of the injuries sustained by the claimant in the road traffic accident. The facts of the case are that on June 15, 2014, at about 12 noon, claimant was traveling in a jeep along with other inmates heading towards Arel village on BM Road. At that time, driver of the jeep drove the same in a rash and negligent manner and dashed against a pedestrian and the capsized jeep, resulting which she sustained injuries. She was aged 38 years as on the date of the accident, and according to the claimants, he was earning 12,000 per month. The evidence of the doctor is that
Page number 20 of the judgment, my lord. Dr. PW, second para.
as per the injuries sustained by the claimant in the accident, she is not able to sit, stand, and move both legs. Loss of sensation below the knee. She underwent posterior stabilization with pedicle screw fixation at T11, L1 with decompression of laminectomy on 18/6/2014 under general anesthesia. A 3T MRI of dorsolateral spine shows that burst fracture of D12 vertebra with spinal canal compromise and cord contusion, edema at conus medullaris and cord region at D10 to L1 level. The doctor had stated that he treated the claimant for last on 25/12/2018. On that day, she was brought in a trolley and she was not in a position to sit and walk. Catheter was inserted. Motor power of hip joint was 2 out of 5. Knee joint was 1 out of 5. And ankle joint was 0. No sensation present below the waistline reflexes are absent, bowel sensation absent, bladder catheterization. The court, according to the doctor, the disability is 75%, and the court had granted the compensation as per the table given below at paragraph number at page number 24, internal page 24. Learned counsel, appearing for the claimant, submits that the as the claimant had lost the sensation in the limbs, functionally the disability is 100%. And the court ought to have granted the compensation as per the law laid down in Kajal's case, considering the state of, considering the physical condition of the claimant. It is submitted that in these facts and circumstances, the liability needs to be fixed on the insurance company. Next, Permanent Counsel appearing for the insurance company submits that the tribunal had rightly held that there is no liability, as it is a liability only policy and the insurance company is not liable. Next, having heard so and so. As far as the liability is concerned, the court had rightly fixed the liability on the owner of the vehicle, considering the nature of the policy, as it is a liability only policy, and this court finds no reasons to interfere. Then coming to the compensation, considering the injuries that are sustained and the 100% disability, functional disability that is suffered by the claimant, in the light of the law laid down in Kajal versus so and so, this court is inclined to grant the compensation. The medical expenses as it is, and under the head of pain and suffering, this court is granting 5 lakhs. Towards the loss of earning to the family members, 8,500 into 4 is 34,000. Loss of future earning, as the accident had taken place in the year 2014, 8,500, 40% future prospects would come to 3,400. That is 11,900 into 12 into 15 into 100% functional disability. 100 by 100 is 21,42,000. Towards the attendant charges, as continuously the claimant requests the attendant, 8,500 into 12 is 1,02,000, and the relevant multiplier is 15. It comes to 15,30,000. Towards loss of amenities, this court is granting an amount of rupees 5 lakh. Future medical expenses 1 lakh, as it is already granted by the court. In the light of the law laid down in Mekala so 10,000. Altogether, the claimant is entitled for an amount of rupees 48,66,492, which is payable by the owner of the vehicle. Accordingly, the appeal is partly allowed, enhancing the compensation from 25,40,492 to 48,66,492. The enhanced amount shall carry 6% interest. Yes.
My appeal is seeking for enhancement.
Their appeal.
And his
No, negligence, is it fixed on the claimant? So you want the contributory negligence to be fixed, and other is quantum. So come to the contributory negligence, that issue number 1. Let's read and understand. No.
Para 11.
Because I have to read, otherwise I'll not understand straight away if you go to that point.
Para 11 of the.
You are a pillion rider.
I was a pillion rider. Rider died on the spot.
No. You want the court to fix the liability on the pillion rider.
Rider is not before the court.
Yeah.
What first? Rider is not before the court. According to them, the negligence is on the driver of the opposite vehicle. So how will we fix the? Charge sheet is filed against whom? Your insured vehicle.
That is self-serving statement without documents.
Let him say, let him say. Driver. What did the driver of your vehicle do? No. Instead of coming to the court, if according to him, he is not at negligence and the negligence is fixed on him and the charge sheet is filed, did he file did he question the charge sheet? Your driver. That I understand. I'm asking, criminal proceedings is entirely different when I ask you this question, whether the insurance company has questioned it. Here, you're relying on the evidence of the driver. Driver is accused. He can very much question it. He has not questioned it. So now some other evidence he can't give. Prima facie. Independently, not relying on the charge and other. Yes. That's why you not make any I will read out the evidence of the doctor. Yes. And then you not make any to the IMU report. IMU report clearly indicates Not make any for a moment. And you look the IMU report. Front portion of both the So what it established? So we'll take it, don't have to look at it. It is a head-on collusion. Yes, next. Yes, read. What he said is left. Read. Even in the evidence report, they are not saying that this vehicle came to the wrong side of the road and dashed against this motorcycle. What they say is from front portion it has come and dashed against it. And even in the evidence also they are saying that front portion it has come and dashed against it. Some other instances taking into consideration the IMU report and other documents. But criminal would have anticipated negligence on part of the right of the motorcycle. Yes. There is no question of whether this driver of the lorry being yes. The driver is given evidence saying that at the time of the accident they were doing the wheeling from the opposite direction. And that's why the accident has taken place. Yes. Pain and suffering, there are about 5 injuries. Court had granted 1 lakh. It is reasonable. Huh? Yes, I have seen it. No. First of all, come to paragraph number 14. Commuted fracture of both bones of right leg, left hand of fibula fracture, right superior and inferior public rami fracture, right radial styloid fracture, and right scaphoid fracture.
As per the doctor, I submit as per the discharge summary, the dismissal of with I am male for the right media and all other instances related contributory. Do not make anything. Whenever this the doctor further says these fractures are united. And further, my lord, you not make any application.
Now, a person, we are dealing with pain and suffering.
One something that happened. Further, my lord, this doctor, he has been treated as a prisoner. He has been treated as a prisoner. He says that when a treated doctor, only for the purpose of disability, he has come before the court and assessed the disability after nearly 1.5 years of the accident. And the doctor further says that the treated doctor is still very much available in the hospital. They are not been covered. And my lord, you was brought to the notice of the court, where this doctor who gave evidence before the tribunal and who has assisted the disability. Here he is a regular doctor in all cases he is coming before the tribunal. So my lord, taking into consideration 21% disability, what the doctor is.
No, when I'm asking about pain and suffering, you have gone to that extent. First of all, please tell the court about pain and suffering. We'll go one after the other. Yes, I said, there are 5 fractures. Yes, that is what I asked. So please come here, come to the, as it is.
Yes, it is.
Then what about the incidental expenses? How many days you were in hospital?
15 days.
Huh?
15 days.
Then why so many 33,000 is granted? So we'll grant 15,000 in under that. Then that's what I said.
Yeah.
Instead of granting 33,000, we'll grant 15,000. Huh? What is the evidence of the doctor? What is the disability? Is it any law? Is there any law which says first of all, you have to hear to my question. Is there any law which says that a doctor other than the treated doctor cannot depose before the court? Number one. Then the doctor who has deposed evidence, what are the grounds to question or to doubt the veracity of his evidence? What is the doubt?
That the doctor who treated the prisoner is available very much. So in such circumstances, can it be believed?
No. No. What is the evidence of the doctor? What is the disability?
63% to the limb and 21% to the whole body.
Court had taken?
Court has taken 21%.
Which year is the accident?
2019, 2021.
How can it be? MBC itself is of, look at it, what is the date?
Yes.
2021.
21 to 21.
2021 is
Yes.
15,000. Huh.
You are doing painting work. And after the accident also, you are doing the painting work. And is earning. So the criminal has awarded nearly 6,10,000 under the future law of body. That is not sustainable. In your law laid down by your lordship and the Supreme Court also. Further, my lord, regarding the future medical expenses, there are 3 fractures cases. And this, my lord, the criminal on each fracture of removal of implant, 30,000 each has been awarded. 90,000 under the future medical expenses.
What is the multiplier?
17.
17.
Yes. (26 years).
At least if you let the court to complete one head, I'll be able to do that. Loss of income during the later period, how did the court come to 85,500?
6 months they have taken.
For 6 months,
I'm granting only 4 months.
yes.
Future medical expenses, what is this amount?
Doctor says 60,000 rupees each for 2
But he will
operations.
say 101 things, we can't. 90,000, how can it be? We'll grant 40,000. Yes. Yes, I will look at the evidence. 1 minute.
Only 2 sentences I read.
Is coming to 9,85,600. It's coming less than what has been awarded by the court. It's a good present. It's coming to, instead of 10,86,970, it is coming to 9,85,600. It is reduced from that. Yes.
In the evidence of petitioner, this is what he says. Now the factors are united. Now I have no disability as such.
Huh?
No, I do not have any disability.
Who said so?
Petitioner says.
Petitioner says so, but he is doing painting work. He has to perform with these.
Who asked you to tell all that?
He has voluntarily said
So what
it.
to do? We have to take his
But
admission.
even though there is an admission, he has to perform with
So then we
great
have to,
difficulty.
we have to accept what he is saying, that a doctor is rose, every day he is coming and deposing before the courts.
No, no,
It is
so
a
far as-
problem
so
of
far
the
as-
claimant.
so
Claimant
far-
says I am all right.
The claimant says, though I am suffering with the disabilities, I am doing the same work and.
What he read is, please tell the court if it is right or wrong. He said.
No, he says, ನಾನು ಈಗಲೂ ಪೇಂಟಿಂಗ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೇನೆ. That means he says that even now I am doing the same work.
No, he
But-
says, I am not suffering any
No,
disability.
that is not, that is.
What does it mean?
No disability as such.
Yes,
No.
show it to him that particular part.
ಅಷ್ಟೇ ಅಷ್ಟೇ ಈಗ ನನಗೆ ಯಾವುದೇ ನ್ಯೂನತೆಗಳು ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. But even then, he has to do that painting work with great
It is not
difficulties.
even then, it is for him who has come to the court, tell the court that what is not all right. He says he's all right. Why should the doctor say that contrary to his evidence?
Doctor says on the basis of on examination, he says he gives the disabilities. But the petitioner says that I am.
Loss of future income, we can't consider. According to him, is absolutely fine. And it is not having any effect on his income. And he's continuing with the same job. Positive evidence. Then the 6,42,000 needs to go. Then we will do one thing.
Amenities.
No, that's what. Loss of, when future medical expenses also will retain 90,000. And we'll add for loss of amenities some more amount. That we will clarify. So loss of amenities, 1 more lakh will grant 50, it will make it 1 lakh. Nourishment, conveyance, that also will retain it. That all that, how much is granted?
33,000.
11 plus 11, that is 33. That 33 will retain.
Yes. Amenities.
We made it 1 lakh. Loss of income during the laid up period also,
For 6 months, the court has granted.
we will keep it 85,500.
It will be more, for 15,000.
It is taken for 6 months. So 15,000
Just
into 6, it comes to 90,000.
90,000.
500, 4,500 more.
Yes.
Yes. 90,000 less. It's coming to 5,41,000 from 10,86,970. Please come. Agreed with the award passed in MBC number 2386 of 2021, dated 24th August 2022. The insurance company is before this court by filing MFA number 8731 of 2022, and the claimant is before this court by filing MFA number 2097 of 2024. The claim petition is filed seeking compensation of an amount of ₹20 lakhs for the injuries sustained by the claimant in the road traffic accident. It's a case of the claimant that on 21/2/2021 at about 11 p.m., while the claimant was traveling as a pillion rider in motorcycle, the offending vehicle, driven by its driver, came at a high speed and dashed to the claimant's motorcycle, where the claimant had sustained grievous injuries, and the rider died at the spot. The claimant had sustained 7 fractures, and he was earning an amount of ₹1,000 per day, working as a painter. The tribunal has granted the compensation as per the table given below at page 18. Then counsel appearing for the insurance company submits that there is a contributory negligence on the part of the rider of the motorcycle. The driver has given a categorically as deposed before the court that because of the negligence on the part of the rider, the accident had taken place. It is submitted that the court has failed to fix a contributory negligence on the claimant, on the rider of the vehicle, and no other evidence is produced by the claimant. Next paragraph. It is submitted that when it comes to the quantum, the doctor who had deposed before the court is a doctor who is giving evidence regularly in all the cases. Further, when the claimant himself has deposed that he is not, there is no disability, and he is all right and is able to do his work, the court ought not to have taken the disability, or not to have granted any amount under the head of loss of future income. It is submitted that on all the counts, the amount that is awarded by the tribunal is on the higher side. Next part, having Land counsel appearing for the claimant submits that the court has failed to grant a reasonable compensation. It is submitted that he is a pillion rider. There is no question of contributory negligence on the pillion rider. It is submitted that the charge sheet is filed against the driver of the vehicle, and the basing on the driver's evidence, no such inference can be drawn by the court. It is submitted that the compensation needs to be enhanced. Next para, having other counsels on either side, is the material on record. First, coming to the aspect of contributory negligence, as rightly argued by the land counsel for the petitioner, there cannot be contributory negligence on the pillion rider, and for that, the evidence of the driver of the lorry also cannot be considered, because the police, after a full-fledged inquiry, has filed a charge sheet against the driver, and there is nothing on record to show that he has questioned the said charge sheet. In these circumstances, basing on the evidence that is available on record, this court do not find any reasons to fix a contributory negligence on the claimant. Then, coming to the compensation, under the head of medical expenses, pain and suffering, incidental expenses, the court had rightly granted the compensation. Coming to the loss of income during the later period, as this accident has happened in the year 2021, 15,000 into 6 is 90,000 under the head of loss of income during the later period. As rightly argued by the land counsel appearing for the insurance company, the claimant is not entitled for any loss of future income when it is his evidence that he has not suffered any disability and is doing all and is all right and is also continuing the same work in those hence the claimant is not entitled for any amount. Coming to the future medical expenses, basing on evidence doctor had rightly granted and this court is not interfering. Coming to the loss of amenities, considering the fact that he had sustained 7 fractures and also coupled with the evidence of the doctor, this court is granting an amount of rupees 1 lakh. Altogether, the claimant is entitled for an amount of rupees 5,41,000. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 10,86,970 to 5,41,000. The appeal of the claimant is dismissed. Amount in deposit shall be forthwith transferred. And if any excess amount is deposited, the insurance company is at liberty to withdraw. Passwords.
But interest on the future.
The claimant is not entitled for interest on future medical expenses. Yes, next. Yes. Where are the calculations? You both. Yes. Where is your calculation? Not your calculation. He said he will give the calculation. Have you seen it? Huh?
I'm agree with that, and accordingly, I find relying upon this judgment also.
Take that. Yes. Have you seen this judgment? It's a judgment of the Honorable Apex, latest judgment, 2025 ACJ 244. Huh? You have a copy?
Judgment copy or not?
Give it to her. Retrospectively, it can be. Supreme Court says it is retrospective. Look at it.
I will give you the copy. Copy of the judgment I will give you. And all that has been discussed in the Supreme Court. And also,
I did not say so. That order of the High Court is upheld. Look at it, tomorrow part heard. If that's the case, we have to confirm this order. Tomorrow, all these matters as part heard. Yes.
one
Take
more
that.
submission.
Huh?
My submission is what the amount which is in the court deposit in the trial court, that may be the order to release.
No, now we are going to pass the order. Yes, give that and give each bundle. In all these cases, the order is file. Hmm.
May continue to refer that judgment.
MFA, agreed with the award passed in M,
Morning I have given your judgment, but you have referred that also there.
in your latest judgment of the Supreme Court.
No, that also your lordship has referred in your, morning I gave one judgment of lordship. Lordship has referred that judgment also in that, Mr. Urmila, whatever, this code is there. That's why I gave in the morning.
Where is that?
I gave in the morning. Your lordship judgment that is. Connected cases.
That is what was there in the file, just look at it. She gave it in the morning.
I gave in the morning, it is a connected case, two cases are there. Lordship has referred it.
As judgment is referred by.
Urmila Haldar, yes, that is referred.
Lordship has also referred in that. It is two connected cases of 9652 of 13 and 9652.
High Court is well discussed and we agree with the view taken. We may however add that a beneficial legislation would necessarily entail the benefit to be passed on to the claimant in the absence of any specific bar to the same. In the present case, the liability of the appellant insurance company has not been interfered with. Only the computation mode and the modality have been further clarified. As we noted, the claim has been enhanced to rupees 5 lakhs as 50% of the component amount was stayed by this court. The same be paid to the respondent in terms of the impugned judgment within 8 weeks.
In para 5 minutes.
Give that, pass on. I have seen.
This is what I gave in the morning, but the lordship said that we will go ahead according to the.
Yes, it is like 5 lakhs.
It is not for us, it's all injury cases.
That's what, accordingly we'll take.
Interest has to be reduced for the full
Yes.
amount.
Whatever amount that is awarded by the court, we will confirm it, reducing the amount. So yes,
Because we have
MFA, yes, MFA, the insurance company is before this court, questioning the award of compensation. Questioning the compensation that is awarded by the tribunal. How much is the amount?
2 lakhs.
2 lakh?
3,000 for each case. Plus, as per 164, death is 5 lakhs and 2 lakhs.
The first is MBC number 3839, isn't it? Uh, 3839, MBC 3839 arising out of MFA number 3241 of 2021. The tribunal has awarded how much? 73,440.
In the MEC number 3813, the MFA is 3241.
When there are batch of cases,
I will give you an MFA and MEC number both.
no, you have written something. What is this?
Only MFA and MEC both have written.
You have written this amount as per your calculation, but you have to say what is the amount that is granted with the tribunal.
I have written it. That is, in first case it is 73,440. As per the schedule. In second case it is 59,000.
I'm not saying it is as per the schedule. What is simple work? Court don't have to tell you. MBC, MBC. What is the MFA arising out of MBC? Amount granted by the tribunal is this. According to your calculation, it should that. Huh?
Normally they are granted.
But and then you are saying there is difference in the amounts.
My lord, I have given calculation as per the 163A schedule. In the morning we.
I think you are confused or you are confusing me. What I'm asking you is, if in on every case it is 2,55,000, 50,000, why should we again go into everything now? I can only record your for submission. 2,50,000 is common in everything. Yes, please come. MFA. MFA 3241 of 2021 is fine. agreed with orders passed in MEC number 3839 of 2017, and the court has granted 73,000, court has granted 2,50,000. Land counsel appearing for the insurance company submits that the claim petition, this calculation that is done by the court is after, it is after the amendment to the section 163A, whereas this accident had taken place prior to the amendment. As such, they are not entitled for an amount of rupees 2,50,000. Land counsel appearing for the respondent had relied on the judgment of the apex court in case of New India Assurance Company Limited versus Urmila Haldar 2025 ACJ 244. In view of this judgment, as the apex court has held that it can be, being a beneficial legislation, it can be retrospectively implemented. Hence, this court finds no reason as far as the compensation is concerned. However, the amount of the interest rate is concerned is reduced from 9% to 6%. Huh?
Bharadra, ಮಾಡಿ.
Huh?
That is my ground, 6% is awarded. I have taken the ground of appeal.
Didn't I dictate it now?
6%.
I've dictated it. I'm so loud.
I could not hear, sorry.
Yes, next.
Sorry, man, I want to make.
MFA. Mr. Counsel, please wait. MFA 3242 of 2021 arising out of MEC number 4660. She has written all that. Look at it. In all that amount in deposit shall be forthwith, and on such deposit they are entitled to withdraw. Yes. All appeals are partly allowed, reducing from 9% to 6%.
Your Lordship, kindly, the amount in deposit may be reimbursed.
Yes.
I appear for respondent number
Yes,
1.
sir. Huh?
Private place, public place.
No further arguments are required. Huh?
Seeking enhancement of the compensation. Liability is the owner of the vehicle. Compensation is awarded.
Because now they have, as far as fixing the liability on them will not arise. Owner is not before this court, and whatever is the finding of the owner, finding of the court, let it be.
I'm seeking enhancement.
That's what, we'll not go into that tax aspect. If you go, you are not entitled for compensation itself. Isn't it? Please come.
Relation of the policy condition, owner is liable to pay the compensation.
First of all, when we have to go into that, we have to say where the accident had taken place. Agreed with order passed in MEC number 789 of 2019, dated 12th November 2021. The claimant is before this court seeking enhancement of the compensation. This court has perused the grounds that are stated and also has perused the compensation that is awarded by the tribunal. In the considered opinion of this court, there are no grounds to enhance the compensation. And with regard to the liability also, the court has rightly held, and this court finds no reasons to interfere. Accordingly, MFA is dismissed. Next. Give it. This is a red petition of 2019. When the matter came up before this court on 24/9/2024, as there is no representation, this matter was directed to be listed for dismissal on 1/10/2024. Then on 1/10/2024, the matter was directed to be deleted from the caption dismissal and directed the matter to be listed on 25/11/2024. Then again on 25/11/2024, the order sheet reveals that the case is fault-wise, none appears for the parties. Then directed and the matter was directed to be listed on 29/11/2024. Again, on 29/11/2024, there is no representation on behalf of the parties. Hence, the matter was directed to be relisted on second week of January 2025. Then the matter was listed before this court on 2/6/2025. Even on that day also, there was no representation on behalf of both the parties. Hence, the matters were directed to be listed on 1/7/2025. Again, on 7/7/25, there was no representation on behalf of both the parties, as the matter was directed to be listed on 22/9/2025. Again, on 22/9/2025, there is no representation on behalf of both the parties. A writ petition of 2019 is not being pursued by the parties, and at least on 10 occasions, right from 2024 till 2025, several times this matter is listed. And in spite of giving repeated opportunities to the petitioners, they are not pursuing the matter. Hence, it appears that they are not interested. Accordingly, dismissed for non-prosecution. Yes, next. Yes. Huh? It has to be heard. List this matter immediately after vacation. Next three. List the matter on any, it will come before me on 15th of October. This week it is not possible. There are so many matters. Yes. Give that. Letter. Please come. This court by order dated 1/10/2024 in WP number 11422 of 2016 has remanded the matter that is in FTP number 26 of 2007 and directed the court to expedite the hearing and dispose of the interim application. Now, a letter is addressed by the learned judge dated 22/7/2025 seeking extension of time. It is stated that in the month of January, it is brought to the notice of the court that the court had disposed of the matter and directed the trial court to dispose of the IA within 6 months. Now, the letter is addressed on 22/7/2025. The order is passed on 1/10/2024. even assuming that such an order is brought to the notice of the court in the month of January, even the 6 months period would elapse by June. And this letter is addressed in the month of July. And it is received on 30/7/2025. And we are in the month of September. Why from July to September this letter is not placed before this court is not known. In spite of repeated orders that are passed by this court, the registry is not placing the letters addressed by the courts before the court. At the first instance, the courts are not following the orders, and immediately, as per the time stipulated, for any reason, if they are not able to dispose of, even before the expiry of such a time, they should seek for extension of time. First, they are not doing it. After the time is lapsed, after a 1 month, 2 months, they'll come up with extension letters, and those letters are placed before the court whenever it is convenient to the registry. Now the judge will start counting the days from the day order is passed. This court has come across cases where for a year or so, the letters are not placed before the court. The Registrar Judicial shall look into this aspect and why, in spite of repeated orders passed by the court, why this much of delay is taking place to place the letters, which is received, to place a letter which is received on 37. It took time till today. Further, even after the letter is addressed, it's already 3 months have elapsed. In that view of the matter, only a 3 months time is granted to dispose of the IA. It is so unfortunate that a final decree proceedings of the year 2007 are still pending, and this is how the delay is caused. Yes. No further time. It is made clear that no further time will be granted. Yes.
Lord, a week's time may be granted. Lord. There is
Where is the petition?
Two petitions are there, Lord.
Huh?
Two petitions are there. One
List
is filed by.
List is matter in the month of December. Yes, next. 5. Of the respondent. You have an interim order in your favor. It's for the enhancement. List is matter on 23rd of October. No representation for the respondent. Is 6.
Appearing for the respondent.
It's a 25 matter. We'll see after vacation. Yes. 7. Interim order earlier granted is extended. Yes. 7. Give that. This maintainability. On what ground? Parity. Maintainability with the refer to same check later. Single WP may not be maintainable. Yes, the office objection is sustained and 2 writ petitions shall be filed questioning the 2 IAs. Yes, next date. No, 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 no. Let them take steps, not maintain. Yes. Give the file. There is any evidence on record? No, no. The evidence with regard to her income. She filed statement of assets and liabilities saying that she's not earning. Your assertion is she's earning. There is no material on that. Your income is 29,000. Court has granted 9,000. How? With whom he is staying now? What is the age of the son? 29,000 you are having, 9,000 court has granted. That is a normal routine story in every case. That we have to see. Let the notice go and come. Land council submits that. His salary is 29,000 and the wife is also earning. He's taking care of the son who is 10 years old. Considering them, they shall be stay 6,000. Arrears also at 6,000 and by 15th of October memo to be filed by taking hands summons. Yes, next. Yes.
Wherein the maintenance has been ordered for rupees
How much?
12,000 melons.
What is your income?
14,000 melons. Working as a carpenter and coolie melons.
Let's see the order.
7,000 for the wife and 5,000 for the child.
Respondent in his affidavit stated that he is working as a carpenter, earning 10,000 per month. Monthly and he is under obligation, so and so. It is submitted by the land council for the petitioner that the petitioner is earning 12,000 per month. Court had granted
12,000.
you are earning 14,000.
13 to 14,000 melons.
Earning 13 to 14,000 and the court had granted 12,000 per month as maintenance. Same, considering the same. 6,000. Arrears also within 8 weeks. And summons October 15. Yes, next.
Serial number 10.1, I am appearing for the respondent. It's a disposed of matter, my lords. They have moved several applications without serving the copy upon us, my lords. Let them serve all the copies, my lords. I will make my submission.
I have served through mail, my lord. I have acknowledged the
It's a disposed of matter, my lords. They
along with
cannot serve it to me. Then they have not informed when it is served, my lords. Through which mail it is served, they have not informed us, my lords.
When you
I
want
appear regularly in
hearing,
court, my lords.
like when you want this matter to be heard,
Please.
it's your responsibility and to ensure that copy is served on him.
Please,
First of all, this court has shown enough indulgence in restricting this matter to him. And on the top of it, if you're not serving papers on him, what can
What happens,
the
ma'am?
court do?
They appear regularly to the court, my lords. He has not even served
RPFC,
me.
RPFC matter was posted earlier last week, my lord. On that day, my lord, no one will appear, my lord. Kindly see the order sheet, my
Lords,
lord.
it's a
Kindly see
disposed
it.
of, please.
Well, now urgency is, my lord, there is, my lord, they are likely to, my lord, disperse the amount. That is the urgency I have pleaded, my lord, before this honorable court. Now, my lord, kindly see, my lord, RPFC matter was posted last week. My lord, no one appeared. Kindly see the order sheet of RPFC, my lord. And that day, no one represented, my lord.
Appears
Now,
that the matter.
The matter will stay the disbursement of the amount.
Lords, it is already stayed, my lords. What has the learned trial court said is that.
not state,
Lords, the trial.
It is not, that is vacated. That's why he is before this court by filing another writ petition.
Lords, in writ petition, my lords, I have no instructions because he has to
What
serve.
we will do
Lords,
is, anyhow you're here.
Lords,
Anyhow
one
you're
request,
here. I
please.
will not, don't take notice.
Please.
What we'll do is, he has filed a review petition in the RPFC.
Please, my lords.
So pending consideration of that, let that whatever the court order with regard to disbursement
Please.
or will be stayed.
Lords, may I make one request, my lords. let the writ petition copies be served, maybe called on Thursday, my lords, I will make my submission. That's
My
all.
lord, till
Let
then,
him
my
serve
lord,
all the copies.
They are making hectic effort, my lord,
But
before the
the-
trial
my
court.
lord-
If amount is, my lord,
What will happen?
my lord, if amount is remitted to the account of the respondent, my lord, the writ
My lord,
petition will become.
I have
in
not
fact,
made
whole
any such
petition
application, my
becomes-
lord.
Give it back to.
I'm only requesting before this honorable court is, my lord, let the, my lord, order be stalled till next date
Let
of
them
hearing.
serve the copies Thursday, my lords. Till Thursday, nothing will happen, my lords.
Tomorrow.
Please, my lord, let him serve a copy now itself, my
The
lords,
copy
please.
today on both the counts. Tomorrow, again, if you come up with the same story, I'm going to adjourn it to December.
Today itself I will serve, my lord.
Right now you serve.
Please, my lord.
The petitioner also serve the copy on the council in RPFC number 68 of 2021.
My lord, as well as the writ,
As
my
well
lords,
as the
please.
petition also.
Writ
I will
petition.
accept notice for respondent, my lords. It's a fresh
2908
matter.
on 2025, he said
Please.
he submits that. He'll get instructions and file Vakala. This is the matter tomorrow. Yes, next.
Please.
Please, my lord.
Matter pertaining serial number 9, my lords. Period of 6 weeks may be granted. It is like 1,20,000 rupees for the
8 weeks, not 12, 6 weeks. Yes, next. 6,000 is the amount. You got confused.
1,20,000. Arrears comes around.
That's what it is, 8 weeks. Yes.
Your Lordship, in this matter, there is a very big urgency, Your Lordship. The reason being, there was an order of this Honorable Court on 16/6/2025 for the petitioner confirming the trial court order.
Impugned order, first you tell, that's easy for the court to follow the case. Where is the impugned order?
Impugned order is in page number 37, Your Lordship.
Please come to that.
Your Lordship, here the reason for the IA to be filed.
Come to the order. Where
38,
is the
page number
order?
38.
IA under section 12 of the guardians and so is hereby dismissed. IA under section 151 CPC filed with the respondent is also dismissed. You are for the father or the mother?
I am for the mother.
Yes.
Your Lordship, here there was a custody order. There was an interim custody awarded to the petitioner mother on 10/6/2025, which was confirmed by this Honorable Court on 16/6/2025, which is kept as Annexure E. And according in the Honorable Trial Court, it was only the interim custody, which interim custody was granted to the mother, but there was no visitation given to the father. Here, this Honorable Court had also given some visitation rights to the father. Your Lordship, while awarding the visitation rights, there were certain conditions. Here, he has violated clause 2 of the order of this Honorable Court, and wherein this Honorable Court in page number 118.
Without hearing them, we will not pass any order.
Your Lordship, now the problem is that every week the visitation is given on Friday evening, from Friday evening till Sunday evening. Here there is a clause which says that the father should not speak ill of the mother in clause 2. My concern is that wherein it is become very serious now, Your Lordship. That is the reason I'm citing my urgency. In page number 121 of the orders of this Honorable Court, Your Lordship, says both.
What is the order you're expecting from the court? That the court should not, modify the earlier order and say that don't let there not be visitation to the father.
No, Your Lordship. Here, in this itself.
Expecting that you tell the court. What
In
is
this
the relief?
In this order itself, the powers have been given to the Honorable Trial Court. If the father speaks ill and there are evidence, the Honorable Trial Court shall pass orders on that.
What is the urgency for this?
Your Lordship is taking the child every week and there are videos I tried to produce.
Let them come,
And
we will see. No
Your
urgency.
Lordship, and he is bringing police to
take
the
out hand
house.
summons on the council appearing for the respondent and
Your-
shall file a memo to the.
Your
effect.
Lordship, the child was even detained in the classroom.
This matter next week after vacation. Yes.
Your Lordship, kindly this order may be kept in abeyance with respect to the final orders.
No. Yes, next.
The child is very much mentally affected, Your Lordship.
We'll see.
Kindly a date may be
After,
granted.
whenever you file the memo, it will come after vacation. Yes, 13.
Much obliged.
This is matter in the month of December. Next 14. At the request of learned counsel for the petition. Your petition or respondent?
Petitioner.
Petitioner, no representation for the respondent.
I represent the petitioner.
Huh?
I represent the petitioner counsel.
Yes, next 14.
My lord, I appear for the petitioner in this matter.
Where is,
My lord,
where is the respondent? You have an intermorder in your favor?
no, ma'am.
This is matter after vacation in the month of November.
May I
Next.
make one submission, my lord? This matter may be called along with one more.
Yes, write in a paper, list along
I'll
with
give
so
it.
and so. Yes,
Please.
next. 15.
If the application filed, the impugned order filed by the family court, my lord, where my application are dismissed, my application is, my lord, I filed application seeking the petition is not maintainable before the principal family court at Hassan is not maintainable for want of territorial jurisdiction, my lord. As the children were studying in the Srirangapatna, my lord, Mandya district.
As?
They are studying in Mandya district, my lord, but the petition is filed by the grandparents of the children in the this court, my lord. May I argue, my lord? Earlier, my lord, kindly see their objection, my lord, kindly see their objection.
As on the day, now, you have filed it now. It's now his place of residence is that at the other place.
Children with the father, my lord, there.
Yes. You know that what section 9 of the Act says. That's what is important. Because where the child ordinarily resides is what matters. No, it was because he was staying some time ago. It would not become his ordinary place of residence. Maybe the whole purport of that order, section 9 is once a petition is filed, the odd may be called to the court, all that. So the convenience of the boy.
The two, my lord, I filled it out.
That instructions. This is smart after vacation. Next.
Intermortem may be extended, my lord.
Intermortem earlier granted is extended till the next. Huh?
The previous actor, my lord, this court was on leave, my lord. It was before the other court, my lord.
Then what to do? You have not asked. No stay.
My lord,
Yes,
kindly
yes, yes.
extended, my lord. I filed necessary application, my lord.
Next after this is matter immediately after vacation. Yes, 17. Yes, next.
I have an interim order, my lords. There's no interim order in this, my lords. This is a petition wherein the father, I appear for the father. We
Yes.
tried, there were settlement talks which could not materialize, my lords. Now, what's happened here is, my lords, that the child, it's a minor daughter who was with the father for 3 days and with the mother for 3 days. The urgency is, my lords, Dasara vacations, ensuing Dasara vacations, my lords.
What is the impugned order?
Impugned order is at page number 25, my lords. Starts at
What did the court say? I number 2 filed by the petitioner.
minor daughter was in the custody of the father under the guise of a function the mother takes. When I filed the petition, she was with the father, the minor daughter. Under the guise of a function she takes and she does not
This
return.
GNWC is filed.
2023.
2023. So,
Please.
right from 2023, the girl is not with you.
When I filed it, my lords, the girl was with me.
That's what I'm saying.
So only after
so
the
2023,
please, please.
she's not with you. So we are in 2025, 2.5 years. When is this filed? GNWC.
My lord, GNWC was filed. One second. Was filed on 19/8/2023, my lords. Subsequent to the filing, my lords, the child was with me. Only after the respondent appeared on record in the GNWC proceedings, what happens is she takes the child away. Then I file an application seeking grant the custody, interim custody to me. That application gets rejected, wherein only certain visitation rights are granted to me. That is from Saturday evening to Saturday afternoon to Sunday evening. My lords, that also is not being complied, my lords. The reason being,
So that will go
Please,
to later.
please.
So Saturday, Sunday was the visitation.
please.
So what do you want now?
My lords, status quo ante, my lords. The child was with the father. My lords, the reason is, my lords, I have
According to you, he should be sent back to you.
no. Let the mother have visitation rights. My lords, the reason is the allegations that I've made.
We'll decide it after vacation.
My lords, then in that case, my lords, Dasara vacation, some access, my lords,
So
please. my lords.
you file these kind of applications And
My
you
lords,
expect the
there are
court to
three
give some
volumes,
other relief.
my lords, there are 3 volumes which I have produced before the trial court in respect of adultery committed by the mother. Her paramour picks up the child from the school. I have a video. I'll have to play it before your lordships. That is the status of this matter presently, my lords. My access to the school is restricted. When I try meeting the child at the bus stop where the child gets off from the bus, the paramour is picking up the child. I have a video, my lords. Those 3 volumes run up to 1,000 pages, wherein the Instagram chats, everything, wherein fortunately I got access to, my lords. If I place it before your lordships, my lordships would have to look into it that.
My lord, all that is a matter of evidence in the JNWC case. My lord. If 2 weeks is not complied with the order because she has midterm exams going on. The previous week, when I sent the doctor to the petitioner's house, the books were not sent back and she had exams. That was the sole reason we didn't comply with it. It's not, my lord, weekend visitation, overnight custody of a girl child. They're giving them on the weekends. They're not even objecting for that. And she's a girl child, my lord, she's 8 years old.
What is the age of the child?
She's 8 years old.
And she is comfortable with the father, my lords.
My lord, mother, my lord, she's comfortable during the week. She's with the mother, my lord. All that has happened.
We'll do one thing in the vacation. Anyhow, she's having a Saturday and she's having a Friday and Saturday.
Saturday and Sunday.
Saturday and Sunday. So as far as these vacations are concerned, let him pick up on a Thursday and send her back on Sunday.
Please.
That's why let him have it from Thursday, one more day.
Dasara schools are closed, ma'am.
And
Dasara schools are
don't go to again 50%. The land council for the petitioner submits that. After filing the petition also, the custody of the child is with the mother, and mother has taken her for a day for some function, and after that she has not she has retained the custody of the child. It is submitted that the present IA is filed, requesting the court to resume the custody of the child to the father that came to be dismissed. Land counsel for the petitioner father submits that the wife is living in adultery and he has placed voluminous record before the court. Next, land counsel
For
appearing
the family court, my lords. Before the family.
for the family court. Land counsel appearing for the respondent mother submits that the mother in fact has been strengthening the child, like she's staying overnight with the father on Saturday, on every Saturday.
Please.
She'll go on Friday and come back on Sunday.
My lords.
This week, my lord, because last week we had missed. So this week they even informed the petitioner saying they'll send a day early from Friday.
My lords, the meeting point is between they live in the same
Is it
area.
Saturday or Sunday? That's what I asked.
He goes on, he picks up the child on Saturday and drops her back on Sunday.
Saturday to Sunday, it is submitted that the court had rightly dismissed the applications and there are no grounds to interfere. Next para. Considering the fact that the Dasara vacation is approaching and it's a holiday for the child. Dasara vacation is between when to when?
Really begun, my lords.
It's already
respect of
started.
Schools, yes, that being the reason, my lords.
On this Thursday, that is on 25th, the father can pick up the child at 10 a.m.
Please.
and shall drop the child back on 29th morning.
Please.
List is marker immediately after vacation. Huh?
My lords.
29th, yes,
Grateful.
next.
My lords, may I request a date, 16th, my lords, if I may request.
List is marker immediate level. It will come. Yes,
Great.
next.
Obliged.
Yes.
Well, I have filed IA 1/2025
Hmm.
for interim custody of the child for a day in pendency of this writ petition.
Huh?
That
Let's
otherwise,
see where is the order of the court.
my lord, otherwise this writ petition may.
Please come to the impugned order. Where is
My
impugned
lord,
order?
this impugned order is with respect to rejection of amendment of the statement of objection.
Then why should we grant some other thing before this court? When that's not the
But
order
since-
impugned,
since
anything,
they- since-
it is
since-
nothing related to the visitation. Why should we decide it here?
Since the trial court proceedings is stayed, but every birthday for every year we used
Why,
to.
when is it stayed?
It was stayed, my lord. So I cannot file application. Let it be disposed, my lord, we will file application.
Where is the interim order?
My lord,
Then this I'll clarify. There cannot, MC cannot be stayed. I'll modify this order.
My lord, it may be disposed, my lord, we will
No,
file
no, no,
application.
no. Why should, if an application is filed, why should the MC be stayed? Why should the MC be stayed?
My lord, it's for amendment, my lord. Impugned order is for
MC of
amendment.
20, now I'll decide it. Please argue.
Yes, please.
Yes.
My lord, petitioner has filed a statement of objection. Respondent has filed MC petition for divorce. Petitioner has filed
Divorce on the ground of?
cruelty and desertion.
Now what is the amendment that you're seeking?
My lord, amendment seeking is at page number. My lord, at page number.
MC is filed in the year 2022.
Yes.
MC is filed by whom?
Yes, yes. Application is also filed on
MC is filed by whom?
respondent, my lord.
Respondent is?
Wife.
Ah.
Petitioner is the husband. My lord, page number 22. Petition has filed IA for amendment of the written statement to insert some additional paras. Evidence has not yet been commenced, my lord. That application has been rejected by the trial
Let's
court,
see.
my lord.
Come to the impugned order. First we read the impugned order.
please.
Then we'll go to your application.
Page number 36, my lord.
36. There's nothing in 36. What is this writ petition 902? 36 is this docket proceeding.
It will start.
38 it starts. The father respondent shall have the custody. I don't think this is the order.
My lord, two orders, my lord. I am challenged only one order.
Where is that?
Year number 9, I have not challenged. My lord, to page number. There may be some error in page number in referring. I will show my lord. Order dated 16/12/2024.
Yes, please read.
Yes, please. Annexure E. Yes. The petitioner has filed this petition under section 13 so and so Hindu Marriage Act against respondents seeking the relief of dissolution of their marriage dated 7/5/2017. Solemnized at Gundi Madevappa Kalyana Mandapa, Davangere. After the marriage, that the petition respondent lived at Rajarajeshwari Nagara of Bangalore and lead marital life. The petitioner was doing work and taken responsibility of maintaining the family. Respondent on one of the other reasons harassing the petitioner and was intentionally obstructing the petitioner while going to the workplace, due to which there was delay for petitioner to report duty in time. It is also alleged that respondent was giving torture to the petitioner. Respondent appeared and filed a objection statement in detail by denying the case of the petitioner. Now, respondent seeking amendment to the objection statement. The proposed amendment is described in the schedule of the application. The respondent has tried for inserting para 11A to 15A to 15M as mentioned in the schedule of the application. The proposed amendment is in respect of care taken by the respondent of his father-in-law and mother-in-law and stated about the amount kept in the name of his child and performance of birthday of the child. The proposed amendment does not touch anything about the allegation made by the petitioner.
No, why do you want this amendment?
My lord, we have taken care of the family of the petitioner also. We have not deserted and we have not caused cruelty.
No, this
Even yes.
proposed amendment, how is it, if it is not, if that amendment is not allowed, how is it going to affect you?
My lord, what is the efforts made by the respondent petitioner to take care of the family of the respondent? My lord,
How is it relevant?
Yes.
How is it relevant?
My lord, we are having cordial relationship with the petitioner. We have taken mother-in-law to the hospital, father-in-law to the hospital. I have deposited amount in the name of the child. We have taken LIC policy. We have celebrated birthday of the child. So this is we are having good relationship with the even family of the respondent. That is
See
the
your
amendment.
objections to the main petition.
Yes, madam. And amendment sought may kindly be seen.
No, before that we will see your objections, original objections.
Yes, please. Annexure B, page number 14. Ma'am.
Page number
14, 14. Annexure B.
Page number
14,
right
14.
from page number 33, the order sheets start.
14, 14, my lord. Annexure B.
14 is in Kannada. Simple 3 paragraphs.
Annexure B, my lord. relevant portion is from para number 11, my lord. Para 10 में कैंडी पेरुस में.
You have not filed any counterclaim. You have not filed any counterclaim.
They have not claimed.
Yes, please come. Agreed with orders passed in I number 9 under order 6 rule 17 dated 6/12/2024. The husband is before this court. The respondent herein, who is the wife, had filed MC number 112 of 2022 seeking divorce on the ground of desertion and cruelty.
Yes, please.
Seeking divorce on the ground of desertion and cruelty. The respondent husband has filed his objections. After that, he has come up with the present application under order 6 rule 17 seeking amendment of the plaint. Now it is the case that it is submitted in support of the IA. It is stated that he is attached to the son, and he has performed the pujas, birthdays, and all these facts he want to state in the amended objection by amending the objections that came to be dismissed by the court, observing that the proposed amendment is in respect of the care taken by the husband of his father-in-law and mother-in-law, and about the amount kept in the name of the child and performance of birthday of the child. The proposed amendment does not touch anything about the allegations made by the wife against the husband. The wife has filed the present case under section 13(1)(1)(a).
And also it includes care taken by the petitioner to the respondent wife at para number 15G also.
Yes, she had seeking decree of divorce on the ground of cruelty. The burden is on the wife to prove the harassment of the husband. The proposed amendment is no way concerned with the harassment alleged by the wife. Therefore, the proposed amendment is not necessary to decide the dispute between the wife and the husband. Already the matter is posted for cross-examination of PW1. Examination of PW1 is recorded on 9/7/2023. Till today, husband has not cross-examined PW1. The order sheet discloses that husband is prolonging the matter on one or the other pretext. Therefore, proposed amendment is not necessary and accordingly dismissed the IA. Then counsel appearing for the appellant submits that, for the petitioner submits that the proposed amendment is very much necessary for deciding the disputes between the parties, and if the amendment is not allowed, it would cause prejudice to the husband. Then counsel appearing for the respondent submits that the court had rightly considered and rightly dismissed the application, and there are no grounds to interfere. Next part, having heard so and so. The respondent has filed the MC seeking divorce on the ground of desertion and cruelty. She has alleged certain grounds with regard to the cruelty, and husband has already filed his objections. Now, by way of these objections, what he wants to prove has no nexus with the allegations that are made by the wife. The court, and right from 2023 till now, the husband has failed to cross-examine the wife. The court has observed what are the laches on the part of the husband in proceeding with the matter. In these, and on the face of it, it appears that only for delaying the proceedings, this application is filed. That is all the more evident where the husband has sought for stay of all further proceedings before this court, and basing on his IA, a coordinate bench of this court has stayed the proceedings And this order is passed on
1/2/2020.
1/2/2025. The impugned order is dated 7/1/2025. And from the last 7 months, the proceedings are stayed. This court do not find any reasons to interfere with the order impugned, where the court had dismissed the application that's filed under Order 6, Rule 17, as there are no merits in the said application. Accordingly, dismissed.
That I will withdraw the IA 1/2025 filed
All
before
will
December
go,
court.
the IA number 1/2025 is filed, seeking visitation rights. This court.
Visiting title for a celebration of the birthday of the killed, 1 day custody.
Celebrating the birthday of the child.
Every year we
This
used to
court do
celebrate.
not find any reasons to consider that IA, as the present petition is filed on an IA that's filed under Order 6, Rule 17. If the petitioner so desires, it is for him to move an appropriate application.
Please.
Yes, next.
For the wife, my lord.
Yes. What is that?
I lost my job. I'm the husband.
When was the job loss?
5th September 2025. After the last hearing, my lord.
After coming to this court, you lost the job.
After 25 years in the same company, my lord.
On? When was the last? That is on 16/9.
It was a chamber meeting, my lord. Before that, he lost the job, but he didn't. Right now, even the document that I have been coming on 5th May 2025. Right now, I'm not having the job. I only request the.
Then what has happened to all the while you have been working? What happened to your bank statement? What is the amount that is lying in your bank? What is the amount that is lying in the bank?
I don't have any money. The only investment is that all my money will be 3 days apart. My wife is staying. My lord, we have filed perjury case. They have hidden the 2 properties, the 2 flats he is having in Vizag, lot of FDs around more than 1 CR. We had filed the perjury in the trial court, my lord. All my investment has been put in the.
Yes, this matter after vacation. Next 21. Huh? Look at it, wherever interim order is there, extend. Yes, next 21.
Also, my lord, I'm not able to pay the money. This honorable court has ordered to pay 30,000 per month. The trial court has ordered to pay 40,000.
Whatever it is, if you are not paid, interim order will go. The day from the day,
my lord,
violation.
May I related submission, my lord.
Then we'll vacate the interim order first.
Because I am jobless and penniless, I don't have any money. How can I pay 30,000 before 5th of December?
So then we'll vacate it. That's the reason why. We'll vacate it. You didn't seek for modification of the order.
No. I filed a petition to say.
You didn't. When the order is passed, after that you didn't seek for modification of the order.
I filed a petition to set aside the trial court order. Petition 25,538.
Interim order, why did you before you that is passed? In your presence it is passed.
Yes, my lord.
Then?
But that time I was having the job, I was getting 1,60,000.
I think you already understand what is the question of the court. You are not answering. For any reasons, if you are not able to comply with the interim order, are you not supposed to file a modification petition?
Yes,
not now. The interim order.
My lord, one small submission, my lord. The interim order, my lord, kindly.
Interim order is passed, directing the petitioner to pay so and so. Till now, no application is filed seeking modification of the order, except saying that he has lost the job. In that view of the matter, the order dated so and so is vacated. Yes, next.
Filing 30,000 per month, my lord.
Whatever you want to do. Yes,
Oblige, my lord.
According to the respondent in this matter.
Yes. Of what?
Of expenses of the baby.
Where is the counsel for the petitioner?
This court has
No
filed-
representation for the petitioner. This is matter for dismissal. Give a date this week only. It will come on 26. Yes, next. Counsel for the respondent is present. Yes.
23 ನಮ್ದು
23 Bella.
Yes.
Should I
Where is
appear
the
for the
stop?
petition?
Yes.
23 Is that 23 Mellon?
Yes.
Mellon, in this case, affidavit has been filed in the office. What happened, Mellon, after filing the affidavit, the advocate on record met with the accident, taken to hospital, completely fractured. I have not been able to get the other information. I phoned him and found out that he says that he has sent it by WhatsApp to respondent. I'm not in a position to, Mellon, I have to get my record. He is not in a position to give me as on today.
So when do you want?
Well, Melody, you will not. I will try to contact Melody and get the copy. If I don't know, Arun, I will want to know from Arun whether
We
he
have
has
not
received.
received. We have not received any copy, madam. We have not received.
So then I have to get it from the advocate Melody, from his family members, and then serve on him.
May I request the
Petitioner,
file?
and petitioner's mother is also. I think Arun knows. Petitioner is in hospital. Arun will know. Vivek's mother is also hospitalized. No, I've not been able to contact anyone.
Madam, after vacation, madam.
Yes, Melody, I'll do it, Melody.
Lord, I appear for the petitioner. Lord, this matter yesterday, they said this child has certain exams. The school, Huh? Oh, please give me. You could have given me earlier. No, I'm also waiting from here all the time. No, why it has become a practice? Advocates both will be there in the court till the matter reaches. The other advocate will keep quiet. Is it that the one wants to surprise the other advocate? Unnecessarily, it will be adjourned on that ground, or sometimes it will be against you. You should have given her. By this time, she could have seen it. I've already filed my counter. I've given my lord. Affidavit has been filed for that. I'm filing my counter. What is this? Exams are till third. Yes. But this is the matter where your lordships. Yes, I remember. What is the impugned order? The impugned order, my lord, is the where the had sought for visitation rights. The trial court holds that the father is entitled for visitation rights. Page number? Page number 30, 21, 19 is the impugned order. At page 30, 31. May just read out one paragraph, my lord, paragraph 15. I number 3 filed by respondent so and so is hereby allowed in part. He is permitted to visit the minor son from 10 a.m. to 1 p.m. on every Sunday near the house of the petition in her presence shall facilitate the to. So, my lord, her presence is something. Let there be an undertaking before the court that neither the father will not indulge in any kind of, giving any wrong advice or talking bad about the mother, except spending good time with him. First of all, I would give this undertaking that should not be taken as that I have done it, my lord. That's an allegation. It's not an. I didn't say. I never said that he did it. I said it is for to create a very congenial atmosphere there. It should be like that. He'll create. The congenial atmosphere. But she is triggering everything, my lord. Her presence is creating the problem. Her presence will not be there. That's what I said also on the last occasion. Very well, my lord. Huh? Yes.
And then we can list it later and there can be an interaction.
So, but the difficulty is 25th is Thursday. His exams are till 25th. And then? So what we do? By evening of when? Before 25th. Then we'll do. On 25th evening for 2 hours, let the father have exclusive custody of the child. We'll take up this matter on 26th. 26th. Based on how it transpires. Very well. It is submitted. This court has interacted with the parties. And also now the instructions are placed by the land counsel appearing for the mother that the boy is having exams till 25th. The boy, what the court has observed is boy is comfortable with both the mother and father. However, it is a complaint. It's a complaint of the mother that the father is unnecessarily is feeding them with the unnecessary things, and he's trying to portray that that because of the mother, all these things have, all the issues have cropped up. And in that regard, an affidavit is filed. It's an affidavit last time.
No, the affidavit is to the effect that he has, I mean, he is looking down upon her, not the child.
Upon, it is only about, he's making the child to look down upon her. The
But we
learned
have
counsel,
disputed
learned
that, my
counsel,
lord.
that's what, learned counsel for the father submits that that they will come up with an affidavit, their objections to the same. It is submitted that my father is not indulging in any of those activities as stated by the mother. It is submitted that as a boy is comfortable, a visitation may be granted without the presence of the mother, so that the father would be able to spend some good time with the child. Considering the fact that on 25th the child is completing his exams, on 25th at 6 o'clock or 5 o'clock?
4 o'clock, 5:30.
5 o'clock. At 6 o'clock in the evening, the father can pick up the child and he can drop back, he shall drop him back at 9 o'clock. He has no exams now, no school by 9 o'clock. List this matter on the next day, that is on 26th, basing on how the visitation went on. The further orders will be passed. It is made clear that the father shall not, shall only try to, shall concentrate on building attachment with the child, nothing else. And the mother shall not be brought into, she shall not refer anything to the mother, either good or bad.
Not pick up from her residence from.
The father shall pick up the child from the residence of the mother at 6 o'clock.
6 o'clock. Drop her back.
Drop her back on
9 p.m.
At 9 p.m. Yes, next.
26 and for the petitioner. 26 and 26.1. In 26, my lord, I had filed a petition with regard to the maintenance which was granted, wherein this honorable court has granted me an interim order, wherein the wife is already receiving rents of 60,000. So therefore.
For the next one, 26.1.
26.1 is with regard to visitation, my lords. My lords, here I would seek a little bit of indulgence. In 23302, the order passed by by the Honorable Principal Judge, Second Additional, is at page number 17. The relevant portion of the order is at page number 24, my lords. 24 of the order. My lords, respondent is permitted to connect with the children through video call over phone every Saturday between 8 to 9. Second, these are the ones which are actually facing fetters, my lords. The respondent is permitted to visit his children every second and fourth Saturday from 10 a.m. to 5 p.m. at any public place near the house of the petitioner. I'm not allowed to take my children anywhere except in and around the house of the petitioner.
What is the age of the children?
13 and 15, my lords.
13 and 15.
15 is the son who's older. 13 is the daughter who's younger.
What is this order?
And my lords, one more aspect, my lords. I filed an affidavit on the 19th. Copy is already served. I have filed an affidavit on the 19th. My lords, may be pleased to take that affidavit, my lord.
Yes.
My lords, may kindly see in page number 12 of my affidavit, I have given the exam schedule. The exams go on till 30th of September, my lords. The vacations are over the page at serial number 40, page number 14 and 15 is the vacation,
yes,
my lords. It commences on the 1st of October and the term begins on the 8th. So 1st to 7th, there are holidays. My lords, in the application that I had filed before the family court, my lords, may kindly turn to page 68 of the petition. My lords, may kindly see the relief. I have sought for 10 a.m. to 6 p.m. from Saturday till Sunday every weekend.
10 a.m. to?
10 a.m. to 6 p.m. on Saturdays. From Saturday 10 a.m. till 6 p.m. on Sunday every weekend. And 50% of the vacation period. And to connect with the children every night between 8:30 and 9:30 p.m. and to spend time on important occasions such as birthdays and festivals. These were the reliefs which I had sought before.
As of now, what is relevant?
My lords, the order of the trial
will
court is
go-
not
will
being
go-
complied with even today.
Consider that order until later.
For the time being, if I can be granted 50% of the vacation period, my lords, I may be permitted to 30th, the exam gets over. First morning, 10 o'clock, I will pick up the children, drop them back on the 4th evening.
Yes.
Then we can have the matter immediately after vacations to discuss the rest of it.
Yes.
My lords, I'll have to seek instructions for the same.
Instructions, tell the mother that whatever, either first half or the second half, whatever is convenient to her and
That's
convenient to
what
the
is being
children.
called a fetter here is actually where the children are having exams right now. And he's expecting the
now.
children to have, it's not a fetter. And with regards to the vacation, I will seek instructions for the same.
Yes, this is matter, they are 26.
May I request 25th, my lords, 26th might be, it may be a heavy day. May I request
No,
20?
26 is where the less matters are.
Very well.
Yes, yes.
Then 26th. Obliged.
Yes. Yes, what is impugned order?
Impugned order in page number 35, Your Lordship. 34, 35.
Yes.
Your Lordship, here the petitioner father had filed an IA for the interim custody of the child, including 50% of the vacations. Here, Your Lordship, she did not file any objections to the IA and did not even argue for the IA. And the order, Your Lordship, the respondent, it reads that the respondent has not disclosed to him where about the minor son is. And
What is the relief you sought?
Your Lordship,
What is the relief you sought?
Your Lordship, because she is living with another man in an adulterous relationship.
I
So
asked
he
you
wants,
what is the
he's,
relief?
he's looking for the interim custody of the child.
That is
and
not possible right now. Then
at least the 50% of the holidays for the time being.
where is that asked?
Your Lordship,
Where is that asked?
in the
When is this DNWC is filed in the year?
DNWC,
Is filed in the year 2023.
23, Your Lordship.
When they are separated?
They were separated in 2020.
In 2020.
Immediately,
And what is the visitation is having from 2020 till now?
Your Lordship, from 2020 till 2023, she was showing the child to the father, and she was even allowing, it is there in his petition, Your Lordship, in page number 53. He's telling that she was showing the child every weekend. Friday he used to go, and sometimes she will be sending the child to him, and it continued till 23.
Oh, this vacation, this summer, this Dasara vacation is a very short period. So keep your, this order of the court, whatever that is granted, it is on what, on every Sunday and public holidays of the school.
From 10
Minus and
to
minus
8.
so on every Sunday and public holidays.
Your
Now,
Lordship,
when-
now the problem
what
is
is
that
the
she left to Bangalore only. She is not showing the child. From the date of the order till today, she is not showing the child, and she filed a memo to that effect in the court. He has already filed for instituted contempt petition also. And Your Lordship, in page number 74, it is when she files a memo in MC number 355 of 2020, he is coming to know that
We'll hear this matter and pass an order after vacation.
kindly some vacations,
Unnecessarily filing another contempt petition. We shouldn't pass an order which can't be executed.
Your Lordship, he is still following and sending her messages
Well,
that.
we'll see after vacation. Yes, next 28.
Much obliged. Your Lordship, one more humble submission. In serial number 11, kindly I may be permitted to take emergent notice may be issued and hand summons.
It's already said. But I already said. Yes, next 28.
Petition. Impugned order is at page 30, my lord.
For the respondent, my lord, I'm filing my objections to the writ petition and memo with citations.
Handed over a copy only about 5 minutes ago, my lords.
What is impugned order? Huh?
Page 30, my lord, my lords, page 32.
No, from now onwards, I'll not take any paper that's filed in the court because of that, we are facing the problem. There are no paginations, nothing. It should be continuous paginations from
We've
that.
done continuous
Do it
paginations, my lord.
before the, yes, what is the impugned order
My
now?
lords, page number 32.
30?
2, my lords.
No, what is the interim order that is passed?
My lords, wherein the application that was filed by the petitioner father was for Dasara as well
Yes,
as.
so the father is permitted to have a video call with the child from today.
I have no objection to that.
23.
I have no objection to that, my lords.
Huh?
The other order that's been passed is in respect of visitation rights wherein which have not been sought for on a weekly basis has been granted by the trial court. But my suggestion is, my lords, the child is 3 years. The child is 3 years, my lords. The
What
trial
is the
court has-
visitation that is granted?
my lords,
What is the visitation that is
8
granted?
hours, my lords.
Huh?
8 hours on
Every
a-
Sunday
8 hour-
from
every
10 a.m.
Sunday,
to
8 hours.
6
Once,
p.m.
I'll just finish. Every Sunday, 8 hours, my lords. For a 3-year-old child who's not seen the father for some time, my only suggestion is, my lord, for 2 years he's not seen the respondent father. My suggestion is, my lords, to
Let
start
him
off
have
with,
on every Saturday, Sunday for 3 years.
my lords, may I request first and third Saturday for 3 years, my lords.
Lord, if I may
We'll
make a submission, my lord.
No, we'll take it up. We'll take up the matter again. Every Saturday and Sunday for 3 hours. Let father
Lord,
have
at
the
least 5 hours
visitation.
may be granted, my lord, in
My
the
lords.
traffic. My lord, as,
Where do
if I-
you stay? Where do he
my
stay?
lord, the father stays in Haryana, but he's willing to relocate temporarily for the next 3 months. He sought permission from his office, October, November, December, he can come and stay here, my lord. That is only in light of the fact that those orders were passed. So this weekend, we will not be here, but from October 1st, he will be here in Bangalore, my lord. So if we are
Here, then we can pass order by October.
October 1st, the father will temporarily relocate to Bangalore for 3 months, my lord. October, November, and December. If weekend visitation,
Coming.
yes.
Because he's here, what we do is instead of 8 hours on one day, on Sunday, on the weekend, and that too like holidays from October.
Yes,
So what
my
we
lord.
can do is on Friday, Saturday, Sunday, every day 3 hours you can have.
My lords.
Friday to
My only submission is, my
Indeed, my
lords.
lord.
Sunday, at least let the mother have some time with the child because mother is also working. Both the parents are working.
Then in that case, Thursday, Friday, Saturday.
My lords. My lords, he's been granted
This,
8 hours. My lords, may I just
Fighting the litigation for the sake of litigation, which
No,
this court
my lords,
will not
indulgence.
entertain.
To start off with, my lords, my suggestion was to start off with 3 hours, my lords. Later, they're always at liberty to
8
file a
hours is
modification.
a problem to you, 3 hours is a problem to you. So what is it? Now letter,
Saturday, Sunday,
it
3
is
hours. my lords, I
submitted
concede
that
to that.
Lord, at least 5 hours Saturday and
My
Sunday, my
lords,
lord, in
I am
Bangalore
conceding
traffic
to
when
the-
he'll travel and come.
October 1st, the father is coming to Bangalore. So from on every Friday and Saturday, he is permitted to have the visitation of the son for
Lord, at least 5 hours, my
for
lord.
3 hours. After the court reopens, we'll hear it.
Okay, indeed.
For 3 hours. Let's just matter on 15th of
My lords,
September.
let them meet the child in Vega City Mall, which is close by to the mother's residence for convenience.
We are
that is
not
all.
opposed to which public place where.
My lords,
Father is permitted to take the child to Vegas.
my lords, the order says it in the presence of the mother. That is the reason 3 hours. My
Why?
lords, please.
Why? What will
To
we
start,
do?
my lords, to start off with, later on, my lords, they'll anyways have liberty to seek modification. I'm not
For the
denying.
first 2 occasions,
Please.
one Saturday and Sunday, father should be there, mother should be present. And the
Saturday.
next Saturday, Sunday, the father
Lord-
can have the exclusive
Lord,
visitation of the
visitation had
child.
been granted for Friday and Saturday, my lord.
So if it is Friday, Saturday, September 26th and not September, October
4th and 5th.
4th and 5th, Saturday, Sunday.
Okay.
Then again on 11th and 12th, 2 Saturday, Sundays he's getting.
Yes.
So one Saturday, Sunday with mother, one Saturday, Sunday without mother. That Vegas Mall, wherever it is, let's just matter on
16th, if I
Lord,
may request.
16th.
6. Obliged, my lord.
There is
And the
also
video calls may
Video calls, my
continue,
lords.
my
In
lord.
fact, on the day your lordship passed an order, we sent an email. He did not even access the video call on
No,
that day.
if it's not
Please.
good for you, video call as per the earlier order.
Lord-
What is
My
the
lords,
order?
may I request at least indulgence in this, my lords? The 15 minutes is too much. The child is not even
Lord,
staying for 2 or 3
they
minutes.
sent a Google
Fine.
Meet
As
link.
long as the child is comfortable.
Please.
Yes, my lord.
The father can
As it is,
speak
they
to
send
the
a Google Meet link and the child is led to be in the screen. The child is not even coming onto screen. We've been patient with that, my lord. We don't have an issue how long it takes to familiarize ourselves with the child as long as we get access, my lord.
As long as you don't settle the disputes with the mother, the child will not
I'm aware, my lord.
familiarized with the father.
I am aware, my
That
lord.
is the order of the day.
We will make all efforts to try and settle the matter itself, my lord.
Yes.
My lords, my lords, in this one more direction, if I may seek your lordship's indulgence. The matter has been deferred to December in the trial court. There is no voluntary contribution from the father. The IA for maintenance is pending. Some sort of a direction for it to be disposed.
Not all that now. Yes.
My lords, please.
Yes, ma'am.
Lords, I appear for petitioner, lords. There's some inconvenience. My seniors, I have informed the opposite counsel also. They are also not available today. Have it after vacation, lords.
After vacation.
Interim order may be extended, my lords.
Delete from part third if interim order is there, extend. Yes, next.
For the respondent, my lord. Today I received the entire papers, my lord. Next week.
Saturday, Friday. Yes, then. Yes. This list is given when? Sriram General Insurance list. Hmm. Yes. We'll take up this matter after vacation. Delete from the caption dismissal. This is matter after vacation. Yes, next. 2 and 3 also after vacation in the month of November. 4 also.
4 notes.
Oh.
Lord said asked us to file written submissions. Lord said that I had made some submissions. Lord said you file written arguments. I filed it. Lord may post it not for reserved for judgment. But because
Both of you filed?
Yes.
yes,
Yes,
Lord said asked us Lord to
Reserved,
file.
reserved.
Can I just make one submission, Lord? I have culled out not the points, not even the admissions in an affidavit and not other
I look
statements,
into it.
which is already
Reserved. Yes, next.
grateful.
Much obliged.
Please.
It is submitted that both the parties, as per the order passed by this court, have filed their respective written arguments. Basing on the written arguments, orders will be passed. Yes.
Much obliged.
My lord, sir, my lord, sir, kindly bear it for 2 minutes, my lord. My lord, this matter petition, my lord, earlier.
Other side is not there.
My lord, serial number 5.1 is the petition filed by the husband. 5 is the petition filed by the
This is
wife,
matter
my
after
lord.
vacation.
My lord, only one small submission, my lord. There is an interim order with respect to pay the maintenance for 6,000 rupees. Earlier, there was a direction to deposit. He has deposited. Further, it has been modified to pay.
What do you expect the court to do?
My lord, he has to pay the. I filed an application at Karnataka to pay.
Understand.
He has violated
I
the order,
understand.
my lord.
What is to be done now?
My lord, sir, I'm sorry, my lord. My difficulty.
There is no. Why are you saying sorry? I'm asking you. What do you expect the court in that 1 minute submission to do?
My lord,
I have to hear the other side and do
that's
it. Is
grateful,
it
my
not
lord.
after
My lord,
vacation?
I have already served the copy, but he says that he is not. He has already given NOC
After
also, my
vacation,
lord.
when the matter comes, we will hear and do not
At least
right
let
now.
me, notice may be issued in my matter, my lord. It is fine, my
Yes,
lord.
in RPFC 248,
Notice may be
notice
issued.
the Mr. Vinod Gowda is directed to take notice.
It was already been ordered, my lord, but he said that he has given NOC, my lord. Now he is saying he is given NOC.
No emergent notice to the respondent.
Grateful, my lord.
Yes, next. Yes. 6 is adjourned. Yes, after vacation in the month of November. Yes, next.
For the respondent in first matter, ma'am.
Yes, this also after vacation. Yes, 8. After vacation. After vacation. Yes, 8, 9. After vacation.
Lord, appear for petition and blood. The trial court, my lord, is awarded maintenance of
We'll see after
12,000
vacation.
rupees.
Yes, next.
Lord, may request in pressing for interim order, my lord. I ready to pay, my lord, 50%.
324 matter, I will not grant interim order.
There is no interim order, my lord. May I requested, my lord, that's why matter is moved before your lordship. May I requested, my lord, to grant interim, subject to my lord, to deposit. Ready to, my lord, pay that.
What were you doing from 24 till now without an interim order?
There is some, my lord, your lordship.
Oh, that will not be
issue
granted at
notice
the
to my
fag end of the vacation, no.
lord. My request, my lord, ready to, my lord, deposit some amount, my lord, subject
No,
to your
some
lordship.
amount. If you're, I'll look at the order, whatever order this court directs that you have to know some. If that you are ready for that, I will look into that.
Lord, I ready to deposit, my lord.
Not, that's what I said. You have to deposit what this court wants you to do it, not what you want to.
12,000 rupees is awarded, my lord.
Then how much you will deposit?
Lord, 50% of the award, my lord. Maintenance.
50% of the
Maintenance of.
And arrears?
But arrears is already paid some amount before the trial court.
For all that calculation is required.
But
If you can get the calculation, I'll take it up
but
tomorrow.
nearly 4 lakhs.
Get the
there was an arrears.
calculation, we will see, make a calculation at half of the amount. How many, who are the respondents? Only
my-
wife or the daughter is?
Mother, my mother is. Blood is the fight between my lord son and mother. Blood is she's left the my lord, the company of this petitioner, my father my lord, in the 1991 my lord. He's deserted the my lord, my petitioner and my lord, his father.
So
Blood
6,000.
is he living in their mother house?
6,000 arrears, please calculate and come tomorrow. This is the matter tomorrow. Yes, please. Yes.
Petitioner wife, my lord. My prayer is very limited to restoration of my maintenance petition, my lord. Restoration of my maintenance petition, which has been dismissed for default, my lord. My writ petition was pending. Earlier occasion, no opportunity for here on IA number 2.
It's
has been
very
given.
simple order.
My lord, page number 24, my lord. Petitioner and respondent got divorced, my lord, in the year.
No, the other has to come. Yes.
Emergent notice maybe.
Emergent notice to the respondent.
And
Yes,
also
next.
to serve the counsel, my lord.
What is pending there?
Nothing is pending, but.
No. That, then we will not order that. Yes. Yes, after vacation. After vacation. Yes, next.
My lord, I am appearing for the appellant in the first matter, my lord. So it is a case of injury, my lord. So records are necessary, my lord, to this case.
Admit
Serial
also
number
fine.
first matter of fourth list, my lord.
Next two. Vijay Kumar, admit post of final hearing, call for the DCR. S3. 3. Same, admit post of final hearing, call for the TCR. So delay is there. How many days? 275. Yes. I number 1 is filed to condone the delay of 275 days. Condoned on condition.
2 weeks time it is granted.
Uh-huh.
The appellant in this matter.
In which case?
Serial number 4, my lord. I will take steps.
Where in that
respond of-
case, my
Three
lord? I
times
represent the
postal
respondent number 1 and 2, my lord.
No such person. Memo charged it was so and so. Yes, for taking steps. 2 weeks time. Default order.
My lord, with
Yes,
regarding,
fine.
my lord, with regarding, my lord, literally,
Huh?
the appellant, he filed a 252 application before the magistrate. He pleaded guilty and he was convicted and he deposited the fine amount. Then,
We have to hear the matter. We have to hear the matter.
then
Yes, next.
kindly have it on Friday, my lord. I produced the certified copy of the trial
Yes,
court.
yes.
R2 is owner of the vehicle, liability challenge.
Admit post of final hearing, call for the DCR 6. Memo is filed seeking dispensation of notice to R3 dispense with at the risk of appellant. Admit post of final hearing, call for the DCR. This also memo is filed seeking dispensation of notice to R2 dispense with at the risk of appellant. Yes. 8.
8, I appear for the appellant in this case, my lord.
What about this, Pradeep? 6, 8.
Copies has not given. The liability is on owner, I think.
IA number 1 of 22 is filed to condone the delay of 60 days. Condone. The petitioner shall take steps for issuance of notice to R1 and R2. 3 weeks time is granted. Yes, next 9. Default
Same,
order.
connected.
I appear for appellant in this case, my lord.
Yes, I delay this IA 1 of 22, not now, after notice. Yes, next.
9 also.
For appellant in this case, my lord.
Notice, same order in this also.
Yes, please, my lord.
In this also, no steps. So,
In 10, I have already taken steps to
huh?
Serial number
10.
10.
10 is not a time. I'm referring to 9.
Serial number 10.
No.
I filed application for extension of time.
What is it? For what?
Huh? List number 4.
List number 410.
Yes.
List number 410, your lordships, I appear for list 10.
10 after vacation. Yes, next 11. This also admit post.
10 will be argued.
Admit post of final hearing. Yes, next.
Respondent in
What's
this matter. Appellant in the connected matter.
Where is Ashok in Patan?
Claimant supply.
Admit post of final hearing. Call for the DCR. 13
Trial court records is coming.
are already there. Admit post for final hearing. Yes, 13.
Appeal for the applicant, madam. By oversight, file a wakalat.
So in which case you have given given up wakalat?
My lordship,
In which case you have given up wakalat?
criminal MFA 31338 already disposed, my lordship. I file a owner appeal. In now a climate, same my miscommunication, we filed a appeal, my lordship.
So something you have after vacation. Yes, 13 after vacation. Yes, 14. What about this, Pradeep? It can be. Yes, this day after tomorrow. 15. This also. Give the number. It is submitted. The connector matter is coming up before the division bench. List along with this before the division bench. Take the number from him. Yes. 16.
Claimant appeal for enhancement. Can you have it tomorrow, my lord? Only enhancement.
Day after tomorrow.
Please, my lord.
Yes, next. 17.
Appellant, Lord.
Uh,
Their appeal also, insurance company also filed an
Raju,
appeal.
admit post for final hearing. This is 17. This admit post for final hearing. No, it's already in final hearing after vacation. After vacation. 20. After vacation.
Appellant, enhancement, claimants.
Vacation. 22. After vacation.
For respondent number 1 and 2. Your
After
Honor.
vacation. 23.
My lord, 23, my lord, I appear for appellant in this case, my lord. It's a memo moved matter, my lord. Kindly may have it tomorrow, my lord.
Day after
What
tomorrow.
about
Day
day
after
after
tomorrow.
tomorrow?
My lord, serial number 23, my lord. It's a memo moved matter, my lord. There's urgency in this matter.
Yes, 25. After vacation. It's adjourned, I think, already 26.
No, my lord.
Pradeep, what about 26? Yes, after vacation. Yes, 27. After vacation. After vacation. After vacation. 29. After vacation. After vacation. Yes.
One submission, Your Lordships.
Yes. What is 11? In 11, so and so for the claimant, so and so is permitted to file wakalat within 1 week. 1 week or 2 weeks? 2 weeks, within 2 weeks. Yes. Huh? See.
One submission, Your Lordships.
May I submit, Your Ladyship? The father's birthday on the 26th, interim custody of the child, and Dasara vacation has not been given. Even the birthday,
Pensioning at 5:50.
because I have filed it today itself, the birthday is on 26th, my lord.
My lord, serial number 6, my lord, list number 4 may be posted along with company appeal MFA 1096 of 20.
Give it to the court office. Where is it?
MFA 10. Good.